So we're good to go.
Evening all, time now is 7:33 p.m. This is the meeting of the Municipal Land Use Board of Borough of River Edge for December 10th, 2025. This meeting of the Municipal Land Use Board of the Borough of River Edge is being held both in person and remotely via Zoom in compliance with the provisions of the Open Public Meetings Act and associated regulations. Notice of this hybrid meeting was published in the Borough Record, posted at Borough Hall, and posted on the Borough's website. The notice included the dial-in and login information necessary for public participation and access to this meeting remotely. A copy of the agenda for this meeting was made available on the Borough's website near the posted, and the notice that included the dial-in and login information. Kindly silence all cell phones at this time. During the public comment period of this meeting, if you would like to make a public comment, you may step up to the microphone and wait to be recognized by the chair. Press the raise hand button on Zoom or dial *9 on your telephone keypad to raise your hand. You may mute and unmute yourself by pressing the microphone icon on Zoom or dialing *6 on your telephone keypad. You must state your name and address clearly prior to making a public comment. With that, I'll ask you to all rise. Let's move the flag.
Pledge allegiance to the flag of the United States of America, to the republic for which it stands,
A nation under God, indivisible, with liberty and justice.
As a matter of housekeeping, preliminarily this evening, we will be having a curfew at 10:30 p.m. At this time, I'll ask council to call the roll.
Mr. Caslin?
Here.
The mayor is excused. Mr. Cray?
Here.
Ms. Boland?
Here.
Mr. Gibbons?
Here.
Mr. Kenigo?
Here.
Mr. Pfeffer?
Here.
Mr. Gautier?
Here.
Councilman Glass is excused. Mr. Salva?
Here.
And Ms. Levine.
Here.
Also present are conflict attorney, Mr. Liebman, our board planner, Mr. Barron's.
Thank you. Good evening, everyone. Our first item on the agenda this evening is under the approval of minutes. We have minutes from our November 19th, 2025 meeting. Draft of the minutes were circulated to the board for review prior to the evening's meeting, and I open it to the board for comment, questions on the draft minutes. Being no comment, I'll look for a motion to approve. So moved. Thank you.
Mr. Salt, who? I'm sure, sorry, who was that? Oh, Mr. Gautier, okay.
Your second? Second. Okay, given by a hair.
All right, everyone's eligible except for Ms. Boland and Mr. Salva.
With those exceptions noted, all in favor?
Aye.
Any opposed? Thank you. Our next item on the agenda this evening is for discussion. We have our schedule for the 2026 calendar year for board meetings. The calendar proposed dates for the meetings were circulated prior to this evening. Any comments or questions from the board on the proposed schedule? There being none, I'll look for a motion to approve. Correct? No second. Thank you, Mr. Kenigo.
You can just do a voice vote.
Voice vote?
Mhm.
All in favor? Aye. Any opposed, any same? Okay, schedule approved, thank you. We'll now move on to memorialization. Applicants is the Barzenas family, Brian and Megan. Address 214 Berkeley Road, block 906, lot 7. The variance granting bulk variance relief for a proposed addition to the home. Draft of the resolution was circulated prior to this evening's meeting for review. Open it to the board for comments or questions on the resolution. None, I will look for a motion to approve. So moved. Go ahead, is there a second? Second. Ms.
All right, and I'll only call those eligible to vote. Mr. Caslin?
Yeah.
Mr. Cray?
Yes.
Mr. Gibbons?
Yes.
Mr. Kenigo?
Yes.
Mr. Pfeffer?
Yeah.
Mr. Gautier?
Yeah.
And Ms. Levine?
Yeah.
All right, the motion passes.
Okay. We'll now move under old business. The applicant is IAAT Services LLC, which was a character from September 24th, 2025. meeting. Property is 41 Grand Avenue, block 1405, lot 4. Application seeking preliminary and final site plan approval with use height and bulk variance relief. Seeking to construct and operate a double-faced static billboard sign on a single pole.
I'm Robert Falcons, I'm appearing on behalf of the applicant. I mean, we'll play with this.
Really?
The mic on. Good evening, Mr. Falcons. Before we get started, there are some other attorneys that are in the room. I'd like to get their appearances on the record.
You heard me.
Remind us who their clients are, helpful. This is a continued meeting we started over the summer, July and September. We're going to refresh everybody's recollection. So let's start with Mr. Kinzel.
Good evening, everyone. Christopher Kinzel. I'm from Arn Abramson. Bob Bakar is my partner, and I'm hearing on his behalf tonight to make a statement also on his behalf. The client that we represent is Grand 4 Associates at 70 Grand Avenue.
And Mr. Sarlo, if you need to give your on the record.
Good evening, Mr. Chairman, members of the board, Councilor Charles Sarlo on behalf of Dark Star Development LLC and Let It Grow Inc., which is going to 41 Grand Avenue, block 1405.
And counsel at the rest of you.
Good evening, Jeffrey Cheney, Kyle Foley. I'm appearing this evening on behalf of Route 4 Main Street LLC, Estate of E. Tamburelli, Trust B, and 41 Grand Avenue LLC.
Is there anybody else here that's represented by?
Okay, I'll just give you a brief procedural summary of the matter. This application was deemed complete on May 28, 2005, and the board has conducted multiple hearings during which the applicant has presented its engineer, Mr. William Voigt, who was accepted by this board as an expert in civil engineering. Mr. Voigt previously has reviewed the survey, the NGDOT outdoor advertising permit, the site plan set, and the sign elevation materials. He described the application as a double-faced billboard measuring 14 by 48 feet and reaching a height of 60 feet, illuminated by LED lighting. The applicant outlined all the bulk variances required, including the front side and rear setback height variance for the district's 35-foot maximum setback. Additional testimony was provided during the light, the sign size, DOT regulatory framework, in the absence of any digital display component in the prior hearings. The board's professional also provided us with written reports, which we expect to address tonight from the testimony of our expert. We have a board's planner memorandum of May 22nd, 2025, which identified the specific variances triggered and confirmed that the applicant requires a D6 height variance, as well as several C variances. And since then, the updated site materials have been provided by the applicant at the continued hearing of September 24th, which I was told didn't work out so well, so there was really no testimony given to them. And that's why we have our engineer here tonight to testify to those plans that previously submitted. We haven't submitted any plans since that meeting, so it will be, onto those plans that were previously conducted. And we have our three experts here tonight, Mr. Bill Voigt, the traffic engineer, Hal Simhoff, our traffic engineer, Hal Simhoff, Bill Voigt, our regular engineer, and our professional planner, John McDonough. And now, we're ready to move forward. Mr. Voigt testify at this time.
Were you sworn for this?
I was, but
You swear you,
sure,
you swear from testimony that the truth, whole truth, from the truth.
I do.
Word.
There we go. You got it works. Good evening. William R. Vogt, Jr. from L2A Land Design. We created the site plans for the applicant. I'm just going to go ahead to this was exhibit A5. It was an aerial that was presented at our last meeting. Just to refresh the board's memory, the site is located at 41 Grand Avenue. North is to the top of the page. We have frontage
along Grand Avenue, which is municipal roadway, and we also have frontage along the Grand Avenue Route 4 corridor. That Grand Avenue is an off-ramp to Route 4. The site is a L-shaped piece of property. It's slightly under a half an acre. It's 0.43 acres. There's an existing two-story office building that's above at-grade parking. So you drive into the site and underneath the building where you park predominantly under the building, but then slow spaces that are around to the north side. What we're proposing, what I'm going to show you is, this is exhibit, we have it marked as exhibit A8A is an apple. This was to be presented at our last hearing, which got carried to this evening. This is just a color rendering of the site plan that was submitted as part of the updated drawings. So it's drawing C-02, it's a site plan, it's revision 3 dated 9/2/2025. So again, you have the L-shaped property, the property is outlined in red. The proposed build or the existing building is the rectangular shaped beige building. All of the gray is the parking that's either beneath the building or to that north that I was speaking about. Access to the site is off of Johnson Avenue. We're proposing to put a 60-foot tall, double-sided static billboard. It's 14 feet in height and 48 feet in length. So it has 672 square foot per side. And it has a V-shaped configuration so that the messaging on the sign is directed towards the traveling public along Route 4. It's a static sign, so it has exterior lighting, uplighting that projects light onto the face of the sign so it can be read in the evening hours. During the day, the lights are off. What we updated from our last hearing and for some of the comments from the board as well as the board professionals, we needed to just show some additional New Jersey DOT right-of-way information. So we had shown that in the blue line work that's on the property. So we emphasize where the DOT right-of-way is. You can see to the north, west, and then to the south east on the site. And then you can see our frontage along the Route 4 DOT right-of-way is on the curvature, which totals 27.27 linear feet. So that was really the biggest update on our plans as far as the resubmission. What we also submitted,
Mr. Moore, you prepared this plan and then you see.
yes, we prepared this plan in my office on the box.
I believe, can we move this into evidence that it has not on there?
I think this is marked as the record as A8 lowercase.
Correct, that's what I have.
That is.
And then what we had shown on the site plans was, we had illustrated, I'm switching to exhibit A8, so that this is the set of plans that were resubmitted. It's a 3-page set of plans, again, same revision, 3 dated 9/2/2025. On sheet CO3, we had an illumination schedule for the sign face, and was asked of us what would be the spillage outside of the sign face. So we elaborated onto that. And I have exhibit A9. So again, it's a
same image of the 14 by 48 static sign. But what we did is we expanded the photometrics to the left, to the right, above and below. And what this is illustrating is the light spillage from those four exterior LED lights to the side of billboard. We are in about 17.5 feet. Our billboard is offset to the neighboring parcel behind us. So the distance between each of the tick marks is 5 feet, so it represents 30 feet all the way out to the right, to the left. And you can see on the sign face, the corners of the billboard, the top corners are around 14-foot candles, the bottom corners are around 24-foot candles, and as you peel away left and right from the sign, at 5 feet, you drop down to 14-foot candles, 10-foot candles. As you go to 10 feet, it drops down even more to 4.5, from 3 to 4.5. At 15 feet, you're at 1-foot candle to 1.4. And then at 20 feet, you're at below 0.5-foot candles, and so on and so forth. So at the approximate distance of the neighboring parcel at that 17.5 feet, we're without any modifications to the lighting or to the sign itself, we're expecting that the spillage at the property line would be in a range of 0.7 to 0.9 foot candles. So with this, with the LED lighting that's available to us for the sign, we're able to dim those light fixtures. So the 4 fixtures can be dimmed. There's in speaking with the manufacturer, there's 10 dimming settings. So we can reduce the lighting output down to by 60%. So we can reduce that output down to only a 40% output. And then in addition to that lighting reduction, the manufacturer makes shielding, or you might hear of this as a outside shield if we were talking about parking lot lighting. So these are the light fixtures that extend in front of the sign. Directly behind the light is a rear shield, but then the manufacturer can also install side shields on either side. So this would help, again, reduce the amount of light spillage off the sides, especially of the N2 lighting unit. So in my conversation with the lighting manufacturer, he had no reservations of getting that light level down to 0 at the property line, using a combination of the dimming and the shielding.
I don't know if this was marked, can you mark this?
So that's actually page 2 of A9.
Oh, yes, that's correct. So A9 is I believe it's a 5-foot set. Yeah. Yes, there was other pictures of the luminaire. The third sheet, these are the 2 shields on the sides. The third sheet, this is just a side profile of the side shield, and then the last page. The last page just shows it illuminated in a dark space, and you can see that it's preventing light from spilling out to the left and to the right. It's projecting the light towards the base of the sign. So those were really the differences or the explanations that we were going to present at our last hearing for this evening.
Okay, thank you. Is there?
Hi, good evening. Just since we last met was July, so just a few housekeeping items. So you went over the extent of variance relief that's required. I didn't hear you mention that you also need a D1 use variance. Are you still under the impression that you do?
Yeah, and we have a planner.
I just want to clarify, 'cause
Yeah.
when you gave the list, I just want to make sure we're all on the same page. With regard to the light spillage issue, I think you mentioned that there's some level of control that could reduce it to 0 foot candles at the property level, the property line. But at the current proposed level, it's somewhere between 0.7 to 0.9 foot candles.
Correct.
I haven't reviewed ordinance compliance. I'm reviewing that on the fly, so I think that's just something we have to consider. I know you said it could be reduced to 0. How does that get enforced when you talk about dimming and spillage over property lines?
Well, I think on other applications, we agreed to a 6-month look back. And we can always, reanalyze it after it's controlled, and certainly do business with the resolution. But we can certainly present, additional documentation, showing, technically that it's at 0.
All right, thank you. And finally, with regard to variance relief, there's a section 416-48B, which pertains to lighting, which just caught my attention while you're talking about lighting. States all business signs and all spotlights and floodlights used to illuminate any sign shall be extinguished by 11 p.m. or upon close of business. So I guess the question is, just as a refresher, are you proposing to illuminate the sign 24/7?
I don't, well, it's definitely not 24/7 all night. I do believe they are.
My recollection was, well, that during the day, it wouldn't be
Yeah.
illuminated. Okay, but the sign would be visible and or illuminated.
Yeah, I do
Throughout
believe
the
that,
day.
yeah.
That's the variance relief. Thank you. When we last met, I think the board requested some additional renderings. So we have the renderings that show the vantage points from the highway. But there's a question of visual impact to other parts of the community. Have you considered preparing other renderings from other vantage points around the site?
Yes, I think we did present, the renderings from Route 4.
Correct. So the board saw those. So we know what it looks like from the highway. The question was, what does it look like from other parts of the community?
Sure, I think we have some other testimony from some of our other professionals that have those, or some of those exhibits. I don't have those in my portfolio.
That's fine. And the final question has to do with the issue of the road classification. As far as you're calling it Route 4 based on DOT classification. You're the engineer, I'm just the planner, but when I looked up this issue using the state's own GIS website and DOT information, it did not classify it as Route 4. Depending on the source, it either classified it as Johnson Avenue or Grand Avenue, and in no case did I find any state source that called it Route 4. So it's just a question of what source did you use to verify that marginal road / off-ramp is in fact classified by DOT as Route 4.
Well, these are from the DOT roadway mapping. So all of the survey, line work was verified through the DOT mapping. My reference to Route 4 is just, because we're within its corridor. So the mapping does go out to what I said before, to the blue, lines that are shown on my plan. That is the extent of the DOT right of way. Anything to the east of this blue line is municipal. Anything to the west is DOT state right of way.
So right of way and road classification might mean two different things. I don't have the definitive answer, but again, when I reviewed the state's own DOT online GIS source, it called it something different. So maybe you found another source that calls it Route 4. Is there a distinction between the right of way and road classification in this case?
It's probably a better question for my surveyor. I can certainly get that for
All
you.
right. And then finally, I think Route 4 in this location, like the actual 3-lane highway part, is 50 miles per hour. Does this segment of roadway have the same speed limit, or does it have other traffic limitations that distinguish it from the 3-lane portion of the highway?
Sure, our traffic engineer is here. So
We will
I
have
think
this.
we can
Okay, that's fine.
probably, elaborate on that.
Okay. That's all I have. Thank you.
Up to the board, Frank, you want to do?
Yeah, I think I was doing. Just want to get a sense of the overall question. Looking at this property and aside from the minimum lot area and the minimum lot width, just about every standard and requirement either has an existing non-conforming existence or there's one being requested. There are 4 that right now meet the standard, meet the zoning requirements, minimum front yard setback, side yard setback, minimum combined side yard setback, and minimum rear yard setback. Those conform and no variance is required. If you're requesting variances on that for the building, which means that I can't find anything other than a lot size, which is larger than 10. That does not have the variance or it has one being requested. Is that accurate?
We will have our planner to start variances, but
You know, exactly on all the requested variance. I agree with your, analysis of our zoning table.
So basically, nothing in that way is applied to the property that would have to go on.
That is the relief that we're there for, yes.
I did have some questions around static signs, and this is really my education. The static sign is someone who the messaging on the sign itself. I'm assuming some sort of large format printing on some sort of outdoor material that's then fastened to the framework of the.
That's correct. It's printed on vinyl, weather resistant vinyl. And we did submit a link to a video on how it is installed and taken down. It's fairly simple, 2 technicians, arrive at the site, standard vehicle, climb the tower and disassemble the vinyl and reassemble the vinyl.
Right, but unlike a dynamic sign, a digital sign, which is in electronic format, that's played and changed to software.
That's correct.
So significantly more cost to change the static sign, to create it, change it, because you have to do one kind of printing, you have to send labor out there to do it. So, reasonable assumption.
I'm only involved in the engineering. I don't get in the costs of the advertising. I can tell you about the digital messaging and how often it changes, but other than that, I couldn't give you pricing.
And then, I guess the last question currently may not apply to you, but I guess, and probably get into later, but I did want to get a little bit, more completed, to catch up with Brent's on, detail on the hardship that's being.
we will have the planner who's.
Yeah, that- that-
That's the plan.
Okay,
It was right. Given?
Yeah, I just have a few, and I don't know if I should have Mr. Behrens or the applicant, but, part of what you brought up, Mr. Behrens, is you were alluded to, do they really have frontage on Route 4? And I think that's really a question, and I don't exactly recall what our ordinance or what is allowed in terms of billboards, but I believe it has to be on frontage of a highway.
Well, one of the threshold issues at hand is that we actually prohibit billboards explicitly, off premises signs. So there are no conditions in which they're permitted. To answer the other question, I don't know the answer to the road classification issue. I know there's some number of feet that the site touches that segment of road, but what it actually is, remains unclear.
Is there some sort of, I feel like there was some, I know we don't have necessarily an urban ordinance, but is there a state or a county that says a billboard has to be on a highway if there is to be one allowed? I feel like there was some testimony to that effect.
Not that I'm aware. I'm not aware of that
Yeah,
sort of
we-
principle or
Sorry,
requirement.
we did testify to that. We have a DOT, active permit for this location.
Which is conditioned upon municipal approval.
Correct. The first step is to actively get that DOT permit, and the DOT vets the site after it's chosen by the applicant or the owner. They go through their criteria, and it met all of the, all of the conditions, and then they issued the permit for us. And that gave us, the opportunity then to get municipal and outside emergency approvals. That's why we're looking forward.
Okay, because it does seem, I don't wanna say questionable, but it's definitely, you know, it's hard to distinguish if it is an on-ramp, or it's a road in River Edge, or it's the actual highway. It's a little different when you get, you know, further down the highway where you pull off and you're right on.
No,
right on the highway.
it's understanding, and I think that's why we, were asked to clarify our exact frontage, and it is only 27.27 linear feet. But that is our frontage, and we did pass the test with the DOT.
Okay, and I don't know if this is a question for you, but this just popped in my thoughts, but Mr. Craig was asking a question. I believe Mr. Costa brought up last time that it might not even really be possible with the site to really maintain the structure. And I don't remember exactly, unfortunately, Mr. Costa is not here, but there was an issue that he brought up that, you know, the space of being able to pull trucks in there and the location of it, that it is maintainable, if that's a word.
Sure, so after our hearing, I met with the driller out at the site. That's where I would say the largest equipment ever comes into the site. I met out with the driller who, drills not only all of, this applicant's, signs, some of the other, owners of billboards that I work for. He also, his crew also drills for them in some pretty tough locations. They're drilling one for me in Jersey City right now. That's 100 feet tall. They looked at the site, they had no issue accessing, through the Grand Avenue right of way. We would probably need to, ask the municipality for a temporary, road closure just to get our equipment in. But the drilling itself only takes about 2 days. They can probably drill and set the foundation and pour the concrete in 1 day, if they go up very quickly. But the largest equipment is the drill rig. So we can access the site, through a partial roadway closure off of the Grand Avenue right of way. And then once the concrete sets and they have the monopole, configured, then we'll crane in, again, from the Grand Avenue right of way. We'll crane in the superstructure.
And what about when that sign needs to be changed, when you have someone new advertising?
So that's the beauty of it. We just would show up in a regular vehicle, access into the site, 2-man crew or 2-person crew, hop out. They have harness equipment, small tools. They have the new vinyl folded up, extension ladder. They climb up. It's very similar to a telephone pole where the rungs start like 14 feet high. They access that, they access to the catwalk, they harness in, and they change the sign out.
I know Mr. Costa has an issue with that, so I don't know if that answers his question, but just, I think that's it for him.
Thank you. Yeah, again, I'm not sure if you're the right one to answer this question, but I'm just curious as to what the process is for monitoring the structure for damage. Is there periodic monitoring? How frequently would that be? You know, if the part of the sign is dangling off or is torn, how is that addressed?
Sure. So, the messaging will get changed, whether it's a month, but someone will be out there every month, regardless. Usually they have to run for 30 days. But not to say that it could run for a week or two. So you're going to actively have people, come to the site to change copies. Normally, in addition to that, they would come out quarterly to inspect the sign structure and workings. There's a apron
that's located below the sign base. It's a 3-foot wide apron. It holds the owner's name on there, and it also holds the permit number. So when DOT passes by, obviously we're on DOT right of way. If there's anything wrong with that sign, whether it's a digital sign or static sign, that number gets reported. If it's not been reported already or known by the owner, and immediately, the owner gets notified to restore and fix whatever's wrong. So the LED or the digital messaging sign, a little bit different, obviously, but, for the static signs, that is the protocol. There's no camera, like the digital sign, for the static.
To your knowledge, is there any plan to at some point convert this to an LED sign?
It's not possible. The two, the out front, digital sign is in Hackensack, just as east of you, is approximately 1,000 feet from us. I would have to be at 3,000 feet from that sign. So this permit could never be transferred to a digital unless the other sign was removed and that permit was vacated. So it can only be a static sign.
And I guess my last question for you is just getting back to the repairs and damage. Do you have any sense of how frequently these types of signs need to be repaired? Any statistics on that, or?
I don't know. I know very few incidents that something has happened, you know, or whether a clip came loose. I don't have any paperwork on that.
Okay. Nothing further, thank you. Thank you so much.
You had provided a worst case scenario for the lighting.
Sure.
Why wouldn't you automatically provide the shields and, you know, provide the least amount of spillage, light spillage as possible?
Well, I think we'd like to present to the board exactly what the sign is itself. It was asked of us if we could, sharpen our pencil and make some modifications to that. So we went back to the drawing board and I think we were successful in presenting that.
Okay, so I would think they want it to be as minimized as possible on the lighting.
Absolutely, and I think we can achieve that.
And also, have you done any kind of a shade study to see what kind of impact you would have on the neighboring businesses and homes?
I did not.
I think that would be something that we'd like to see.
Where is north on your plan?
North to the top of the page. You want to be here?
I'll trust you. So it's oriented where north is at the top.
Yes, the plan, the north arrow is to the upper right hand corner. So the plan and the aerial are oriented in the same fashion, so. I mean, we're pretty much in the C2, and adjoining C1, zones, residentials, farther to the north.
Well, I know one of the businesses, the empty lot presented before us, and we approved a rooftop patio type situation where that may affect their, you know, their rooftop that we approved.
Is that a residential building?
No, it's in the vacant lot, but we approved a commercial building, but with a rooftop.
Commercial, okay. Was that a use variance?
No, it was not no, office uses are permitted in the zone.
Okay.
That's all I have.
Ms. Woodruff?
No questions at this time.
Mr. Salvo?
No questions at this time, thank you.
Go ahead.
Thank you. Back to the maintenance of the sign, you said when it would be put in to begin with, you'd have to have the road closed, ask the borough for the road closed for a day or two. But the maintenance of the sign, you said that the people who were, you know, changing the sign over would be in a standard vehicle.
Right.
what do you consider a standard vehicle?
Any size vehicle that would fit into any of the standard parking spaces that are on the site and can fit underneath the building. Typically, they come in a small pickup.
Oh, okay, so it would be in the parking lot.
Oh, yes, yes, it's, after the sign is installed, or the foundation and the superstructure. Access just to change copy is just onto the site, you know, I could show up in my SUV with another person, and if I was qualified, I could pop up there and change the copy myself.
Thank you.
Thank you. How tall is the tallest, building or structure in River Edge?
The zone that we're in, it's 2.5 stories, 35 feet. So I think most of the structures in our zone and surrounding us are at the 35 foot.
Do you know of any structure in River Edge that's, over 35?
Offhand, in the area, I don't. I know there's some taller buildings, that are probably in Hackensack, that are farther to the east of you. I think those are some of the buildings that you see in some of our perspectives. But just in general area around our sign, I believe everything's around 35 foot.
I'm not asking about the general area, I'm asking about River Edge.
Throughout your municipality, I don't know off the top of my head.
If the sign is built and it falls, will it fall on its own property?
The sign's not built to fall.
If it does fall, we have had tornadoes here in River Edge, things do happen. If it does fall, will it fall on its own property?
That's an interesting question.
Thank you.
Yeah, I don't know if I have an answer for it.
What were your considerations for the height of the sign?
We are cantilevering the existing building. So I'm just gonna switch back to the site plans. Sorry, I think that's 8 are the site plans. The third sheet, CO3, this is an elevation view. So you can see the existing 2-story building over the parking, is at the 35 foot mark. Our sign, the top of it is measuring 60 feet, above grade. So that's leaving us, the 3-foot catwalk and apron underneath it, and leaving us, approximately 9 feet of clearance, between the bottom of the structure and the, top part of it.
Why double-sided?
Double-sided, to present the advertisement to both traveling publics, west and east along the Route 4 corridor.
And do we have any pictures of what would it look like from the other side? I know that you have pictures from Route 4. Do we know what the other side, the northern and eastern sides will be looking at?
I don't have them, but I believe some of our professionals may have them.
Has the foundation met the requirements of the storm water management here in town?
I'm
The
sorry.
proposed foundation, does it meet the requirements of storm water management here in town?
Yes.
How so?
It doesn't require any stormwater management. It's 30 square feet of disturbance.
I would argue the property requires storm water management because it is pretty much all concrete and covered, right?
Pre-existing, yes.
Right, and now you're asking to expand even upon the pre-existing, correct?
For 30 square feet, yes.
Okay. And have you, considered that you're adding 30 square feet to an area that already is totally covered? And therefore, there should be some storm water management consideration given?
We reviewed that with the board engineer, and we didn't get any stormwater comments.
if there is a requirement for road closures and there's a requirement for us to hire police or other officers to man those road closures, are the owners willing to pay for the hours that our cops will have to put in?
Of course.
And that goes for any time in the future that this happens, yeah?
That's correct.
How often is the sign changed?
Typically, it's once a month. Usually the ads from my years of doing, signage, it's typically once a month. Doesn't say that an ad can run shorter than that, or longer than that, but typically I'd say the average is 30 days.
Is there any state regulation that prohibits these types of billboards within a certain distance of an on-ramp or an off-ramp in the highway?
That is part of the DOT criteria. So they did vet all of those, items, and that's why we were issued the permit. So we met all of the criteria. From off ramps, on ramps, scores,
What are those criteria?
they're listed in the DOT manual.
I'm not trying to put you on the spot. If you don't know them, that's fine.
I just don't have them in front of me. I can direct you to the section. I just don't have it in front of me. I don't want to put our traffic engineering spot either, but, we can get you the, criteria.
Is it possible to drop a sign and to make it fit within the 35-foot high restriction that we have here in River Edge?
Not with the current, configuration of the existing building, no.
Why not?
The building is, in the area where the sign is permitted by the DOT. So this location is the location that, we are subject to.
And I'm saying you can't drop the height of the sign?
No, again, the elevation on drawing CO3, I'm leaving 9 feet, I'm cantilevering over the existing, I'm gonna call it a 3-story building. So I'm leaving 9 feet of clearance between the bottom structure and the top of the roof.
And is that 9 foot, and I just don't know, is that required by statute? Is there a reason for 9 feet? Is that number that you keep saying?
I just try to keep it off the roof as much as I can.
If you dropped it 10 feet, would it be touching the roof or would it be in front of the roof?
If I dropped it, I only have 9 feet.
I understand, that's what I'm asking, like, is it right over the roof or is it, because from the drawings, it looks like to me that it's in front of the roof, not over the roof. That's what I'm not understanding. Maybe I'm just misreading the drawing.
I'm just going back to the rendering. So
Yeah.
we have our rectangular existing 3-story building. Here, our monopole is out in the corner, I'm gonna call that the southern corner.
Yeah.
Then we have a flag configuration of the sign above. And it cantilevers, I believe it's 11 feet on, the northern side, and I believe this is 26 feet on the southern side. So that's cantilevering over the existing building.
Okay, got it. All right, that's it for now. Thank you.
Well, I just have a couple questions for you. Excuse me. You mentioned that the sign is made of a vinyl panel.
No, it's a piece of vinyl. It's one piece that's folded up and brought to the site.
Okay, so it's basically unfurled and secured to the signboard?
That's correct.
Okay. What would, if the mechanism to secure the sign to the board would fail, what happens to that vinyl piece? Is it catch, does the wind catch it, blow it onto the highway, does it fall straight down? What's the?
There are several straps. If I don't know if you got a chance to watch that video that we submitted, but there are several straps, both on the top, the bottom, both of the sides, that security. So there's multiple straps. Everything's held in with grommets, secured to this to the side. In my 20 years of doing billboards, I don't know of one that's got away from the side.
Okay, suppose you had a catastrophic failure, what would happen to that piece? Like I said, does this fall straight down? Is it designed to fall straight down, or is there a possibility that it gets blown onto the highway or down onto the street below or onto the roof of the building?
I mean, it is a piece of vinyl, if it got detached somehow hypothetically from the sign, I mean, that's a pretty big hypothetical. It would fall down and if the wind caught it, it would go with it. It is heavy, I mean, but if the wind is strong enough, sure. Okay.
And just, as far as the engineering of the sign goes, with the way it's cantilevered over the building, if there were a failure of the monopole or the way that the sign attached to the monopole, where is that sign falling? Is it falling into the building or is it falling straight down? How is that accounted for?
So you will get full structural drawings, they'll do a boring, to test the soils. So there'll be a fully engineered structural, putting in foundation as well as, superstructure, structural, calculations, all of the attachments, that all get submitted to your, and prior to building, permits. Signed and sealed by, New Jersey licensed, engineers, and that is done across the state, across the country, they're all pretty much done the same way.
Is it unique in the sense that you have this type of a design where you have a billboard situated over a building? So
No, that was pretty common.
Can you give one example in Bergen County that has a similar configuration?
No,
Just one.
The two out fronts that are just, to the east of us, those, at least the one on our side sits on an arm. So that one is cantilevered, off this foundation. I have a couple, I'm trying to think just for the county. I have one in Paramus, at another Dunkin' Donuts, that one has a cantilever and it's a flat shape.
But over a one-story Dunkin' Donuts.
Sure.
One quick follow-up, you mentioned the state permit, I have a note that it expired May 15th and had to be renewed, is that been done?
yes, it has been done. So they don't reissue the actual, permit. There's what they call is a run copy. So every year, the applicant or the owner has to, pay the fee and re-up their, license agreement for that permit. So we did submit the permit run, which was behind that expired, sheet. So it is, through 2026, I believe.
Yeah, thank you. I just had another question. And I don't know, maybe council can answer this better. I'm just wondering if any arrangements or agreements have been entered into with the building owner as to, whether you are obtaining any rights over that building, whether it's an easement of some kind or any kind of rights that would preclude the building owner, in the future from potentially raising the height of its own building. If they wanted to add a structure to the height of the building, you've got your sign hanging over their roof. Potentially, I would think that infringes upon that building owner's right to increase the height of its building.
I know he has a lease, which would cover and stop space over the building for the sign. That's generally how they do it. I personally didn't negotiate the lease, but I've seen them, and that's generally.
Do you know how long that lease is? The term of the lease?
It's generally 30 years. They're long-term leases, but I don't know when specific.
And typically, there is an drawn as part of that lease, for access and maintenance to the sign. But again, the existing building is at the 35-foot height limit, so they would have to come before your board for essentially a new variance.
Right.
And if they're, more than 10%.
And if they did come before the board and say, we want to build a structure on our roof and that's going to increase the height, what would your position be?
It
really depends on the lease.
Right. So is that lease actually in effect, it's been signed?
Oh, yes, we wouldn't be here, we would never like.
Okay.
Okay, just one more question. I'm just looking at this. So the green space that is essentially where the pole is going to be,
Correct.
is that all existing at this point? Is that all green space and not?
Yes,
Not- so
yes,
all-
yeah,
right.
everything that you see on here that's green is green to that.
Okay, so then there is circulation underneath the sign. Cars were driving underneath the sign.
Yes, if you look at my site plan, and you're probably too far away from here, but you can see the striping of the parking spaces that are below the building on the ground floor, and then it L's to the north in the back, and then you continue with the heading spaces towards Route 4 or Grand Avenue, and the neighboring parcel.
So is there any issue with cars driving underneath this? You have other ones that have people driving.
Almost every single one I do is the parking lot, and for a parking lot or a building.
And is this changing, are all the parking spaces that are currently there staying?
There's no impact to any parking, circulation, or function of the property as you see it today.
Okay, thank you.
Objectors council, which will be heard. This will start with you.
Sure.
Everyone, as indicated earlier, my name is Chris Kinsel. I am a partner at Picard and Abramson. I'm here tonight, on behalf of my partner, Robert Picard. Picard and Abramson represents, Grand Four Associates LLC, in opposition to this, application for a variance. I'm just going to read, Mr. Picard's statement, as he is, out of state right now, wasn't able to be here personally, and wanted to make sure that this was read personally to all of you. So you'll allow me.
I'm just gonna interrupt you, just a point of order procedure, so. We're gonna present witnesses for questions and answers, examination, direct examination, with time for public comment, like statement. You want to read comes at the conclusion of all the testimony.
Understood. So I will, I will
So
go back to my seat
so you
and
have-
wait for you to call me back up. I thought I had heard my name.
You did. I didn't realize you were gonna read a
Just again,
statement.
question.
Understood. Thank you.
Anyone to join? Mr. Sarlo?
Good evening, board members. Again, Charles Sorlow on behalf of Dark Star Development LLC and Let It Grow. They are the property owner of block 1405 lot 3, which is 335 Johnson Avenue. And that's the property that was referred to by Ms. Folder earlier in terms of us appearing before this board about 2 years ago to get an approval for a two-story office building over parking and a rooftop amenity. And that rooftop amenity, just to refresh the board member's mind, is more than just some plants. It's a real rooftop amenity for the purposes of the visitors and the employees of the office. It has a kitchen up there, it's got seating there, it's got plants, so it's a real amenity and benefit to that particular piece of property. With that said, I did have the opportunity to cross-examine Mr. Boyd on Zoom back in June or July of the last hearing. So I just only have a few follow-up questions based on this testimony this evening. So Mr. Boyd, you prepared this site plan, correct? Sorry. Okay. And on the site plan is the proposed billboard cantilever over the building. That's right. Okay. So as part of your assignment, part of your scope to position the billboard on the site?
Yes, based on the DOT permit.
Okay. So there was dialogue earlier, a question from Ms. Bowler about whether or not you were aware of my client's office building, and correct me if I'm wrong, but it appeared that based on your dialogue back and forth, you were not aware of that proposed development?
Correct. I personally learned it at our first hearing, when you guys.
Okay, and it seemed like even this evening, you were asking about, like, use variances, yeah, what that, but. So my question is, if you prepared the site plan and you placed that billboard in that location 17 feet off the property line, and you were not aware of my client's proposed development, your placement, correct me if I'm wrong, your placement did not consider the impact on adjoining properties.
Well, your building behind us would be set to the same criteria, the 35-foot mark, so it would be no taller than our existing building. Is that correct?
And that's not the height of my client's building.
Higher, is it higher than?
Well, I'm not specifying.
Okay, it was asked of me if I knew the other application, and obviously I don't know it.
So that's my question is, it's really a yes or no. What your proposed siting on this site or the proposed billboard did not take into account the impact to adjoining properties.
That's why we have our plan.
No, but you prepared the site plan.
That's correct.
So the proposed location did not take into account the impact of adjoining properties. Is that correct? Yes or not?
I don't believe I'm impacting any other adjoining properties by the placement of my billboard.
But again, I'm gonna ask just one more time. Did your citing of the billboard take into consideration the impact to the neighboring properties? Either what's there now or what could be there?
I believe, yes, I have because of following the DOT state permit.
But the DOT is on the south side.
I understand, but
What about the north, what about the north side?
I wouldn't be here without that permit.
That's fine, but what about the north side properties?
The north of this, well, it's really any direction of the property. It doesn't matter north, south, east or west.
So, I think your testimony just covered, you're not aware of the proposed development on my client's property, which is lot 3, the details of it?
I don't know the details of them.
And Mr. Chairman, thank you, Mr. Boyd.
Sure.
Mr. Chairman, Councilor, just procedurally, there was references by Mr. Boyd in terms of video. He said, links 1 or 2 times. Have you been able to watch the video?
So-
I haven't seen that video introduced into evidence.
So my recollection is that it was played, Wisconsin. And I do remember looking at it, I just don't remember if that was in my office or on.
I think,
Yeah, yeah, and it was distributed to the board.
I know at the June and July meeting, the board members asked questions about how the signage would be replaced, and I'm presuming the video was submitted in response to that, but I
Yeah, I'm just
haven't heard
looking
it
at to see-
introduced into evidence.
I'm looking in my emails to see if I have an evidence or if I can about that we played and watched it together. It was another thing, it is part of the application, it is on the Alberta website. It has been submitted to the board, it's part of the app. Have you had a chance to watch it?
No, I was anticipating if it was going to be talked about, it would be introduced here so everybody could kind of watch it and question
Yeah, I think that would
it.
be a good idea,
I'm only bringing it up because he referred to the video 2 or 3 times in his testimony.
and I think we should spread out the record, has everybody on the board had a chance to view the video?
I can try and pull it up, I think.
It's pretty short, I'm not watching it, it's basically a video of some guy showing up in the van, the guy in the van, they pull the piece of vinyl out of
Yeah,
the
but you
van.
gotta, but
They
it's
find-
gonna be used as evidence.
Well, see,
I
that's
mean, it's got to establish
So-
foundation, get into evidence, where did it come from?
What are you doing,
Is this a YouTube video?
well.
Right.
It's,
Well,
I
good.
remember
Is
watching,
that right?
it's pretty self-explanatory. I don't think it's anything more than illustrative of how these stunts. First slot.
We're gonna watch this before it gets moved into evidence.
We're gonna start arguing about the rules of evidence strictly apply here. You wanna know who took the video, Sarla? Are we gonna do that? Put your objections on the record. Yes, it's going down.
You just asked. Outstanding.
Is it just this link right here?
No, not the tab.
Is it-
Go to the tab all the way to the right. Yeah.
This?
It's a link to a search result.
Do you know which video it was?
Isn't there a link at the bottom of the, River Edge page for the Helmet County video?
Yeah, but I just clicked that
The
and,
one at the bottom?
yeah,
That's a document.
and I clicked the link and it just led me to this Google page. This one?
Second part. So I would think a short form.
But I don't know, I don't think I see sharing it on my screen. I'm not as good at this as you are, Tom. Right, I think this is right.
Thank you, Counselor. And then one last thing, Mr. Chairman, it was brought up about, potential lease. I would just, respectfully request that maybe the board consider, asking the applicant to produce that lease for review. I think it's gonna be relevant, to this matter. I have nothing further.
Yeah, please, so. Mr. Cheney?
Good evening, Jeffrey Cheney, counsel for Route 4 Main Street LLC, State Temporarily trustee, and 41 Grand Avenue LLC. Can you just identify the boundary between the property and lot 6?
Sure, you wanted the distance between our property and lot 6?
Yes, please.
Sure, it's lot 6, and correct me if I'm wrong, that's the triangular piece to the west of us?
Yeah, that's my understanding, that's you, but that's.
Okay, yeah, just clarifying, we share the, westernmost property line. You're the property, between, the portion of the Route 4 or state DOT right of way and our property, is this triangular piece.
And so all construction can occur without disturbing that adjacent lot,
Correct,
without needing to access that adjacent lot?
that's correct,
Operation can occur?
that's correct.
Is there sufficient room between the billboard overhead and the building, the roof of the building?
Yes, I presented before, we have the 9,
But that 9 feet is sufficient,
that's correct.
and that's sufficient to access the rooftop equipment?
Any rooftop equipment that's on there? Yes, to my knowledge, yes.
There is rooftop equipment, are you aware of rooftop equipment on?
I haven't been on the roof. I can certainly look into that information for you.
From overhead, can you identify equipment on the overhead?
It does look like there's some air handlers or, HVAC equipment, along the center of the roof. It actually looks like our sign, doesn't come out that far, so we probably wouldn't, even cantilever over those units.
So it's sufficient to maintain that and all that equipment,
That's correct.
as well as to make any repairs to the rooftop itself?
Yes.
How do you write the dimensions of the sign?
Sure, as part of the, DOT permit, that stipulates what the maximum, sign size is. And then we, go to the site and we identify the height, as it's in the permit and the different, sign dimensions. And we chose a 14 by 48, that's the standard size. For the sign, I believe our permit is for a larger sign, if I'm not mistaken. But we went with a 14 by 48, which is I'd say a more typical or standard size.
How is a double-sided sign different than 2 signs?
Double-sided, meaning that there's a face, facing.
There's 2 faces, correct?
There's 2 faces, correct, and that's the face, the west or eastbound traffic along the DOT corridor.
How is that different than 2 signs?
It's one sign structure, I guess it would be the definition, the municipal definition of sign. Some definitions, consider a sign, with 2 faces.
Are you aware of the municipal definition of sign here?
I don't have it in front of me, but I'm sure we can look it up.
Are there any other billboards over buildings in the borough?
I think the question, was asked earlier,
I think it was more broadly asked.
was more broadly asked. I don't know offhand in River Edge, if there's another billboard, cantilever in another building. In other municipalities, yes. I don't know off the top of my head.
And I know we discussed previously, previous council here regarding the design taking into account their building, the proposed building, but the design of the sign taking into account the existing nearby properties.
I'm sorry. Can you repeat that?
The design of the sign taking into account the existing nearby properties.
Yes, I think you're gonna hear testimony from our planner, that justifies that.
And is the DOT concerned with impact beyond Route 4?
probably, again, a better question for a traffic engineer, but, they look at, the site as a whole, within their corridor, but, there's a checklist that they go through and then they vet the site out, so, it has to be in a commercially, zoned, property, you can't have residential on it. So they do, I would say they go like beyond their right.
Nothing further. Thank you.
Thank you, Mr. Chen. Williams.
Yeah, we're ready to call the next witness. I'll call.
I'm sure there's no one else from the public.
Yeah, anybody from the public wishing to be heard?
Yeah, a couple more questions if you don't mind. Is that possible? Or is that too long? Yeah, thank you. When was the building that is currently there built?
Yes.
That I don't know. I would have to check the tax records. I don't know off the top of my head.
Do you know whether any variance was ever granted, for coverage for that property before you guys came to us, for this application?
That's probably more of a land use, question. I don't know that.
All right, well, whoever's gonna testify to that is gonna be upcoming, so that's my question for, whoever's gonna talk to that. And when was the last time the parking lot was repaved?
I don't know.
Has any consideration been given to, fires, and how firefighters will deal or respond, to fires, especially since obviously there's, going to be lights and electricity and, vinyl?
We didn't get any comments from police and fire, services from River Edge, to my knowledge. So I don't have any comments from them.
Was all this submitted to them?
It's part of the application, yes.
Do we have a verification that it was submitted to them and they've chimed in and said?
I believe so. I'll confirm that everything was sent,
Okay.
but usually for commercial applications, Ed would forward them to the departments.
All right, thank you again.
Sure, no problem.
One more, just check with the public, anyone from the public should be. Okay,
Thank you.
And I don't see any hands on Zoom either, so.
Yeah, I would like to call our traffic expert, Mr. Halsall. I believe this is his first time testifying on this application.
Not the first time, I've worked before, but. Who's your dear and we swear from the testimony about this, the truth, all the truth, and so beyond.
Yes, I do.
And smart ordinance.
Can you please state your profession? I'm a licensed professional engineer. I have a planner's license as well. I've been in the practice of traffic engineering since the middle eighties. I've been before, but maybe not the land use board, but planning board and the zoning board in the borough previously been qualified. I have a civil engineering degree from New Jersey Institute of Technology. And I also I'm a fellow with the Institute of Transportation Institute.
And have you been qualified before other boards to serve as a traffic engineer?
Yes, throughout the county, as well as the administrative law courts and the Superior Court
And that is in New Jersey.
in New Jersey.
Have you ever been before this board?
Not the land use board. So it was before it was converted to a land use.
You were separate at one point.
Well, I'll offer Mr. Chairman, Mr. Chairman, Mr. Simhoff is an expert in traffic engineering.
Yeah, question from the board as to qualifications and discussion.
I just had a comment. Could you please just speak closer to the microphone, both of you? Thank you.
Mr. Simhoff, what was your scope of engagement with respect to this project?
I was asked to look at the safety and the practicality of this application as it relates to traffic safety.
In undertaking your engagement, what materials did you review or consult?
I reviewed the DOT permit. I was familiar with somewhat familiar with the DOT criterion. And then I've also reviewed the site plan, and I also reviewed a study done by the FHWA, Federal Highway Administration, as to the safety of billboards.
And have you physically inspected the property to undertake your engagement?
Yes, I have,
And you know approximately when you were there?
through the summer of this year.
So are you generally familiar with the surrounding area and the properties?
Yes,
Did you perform an evaluation to access the traffic and parking impacts of the project, to assess the traffic and parking impacts?
well, there are no parking impacts. And then I looked at the traffic safety aspects of the billboard.
I show your report dated, June 5th, 2025, entitled Safety and Traffic Analysis. Did you prepare this report?
Yes,
Is that your signature and seal on this report?
yes,
Could you briefly describe the findings and conclusions of this report?
sure. I'll start with the global aspect. The Federal Highway Administration regulates billboards under the Highway Beautification Act. And so the federal government presents standards for billboard placement and location. And then they leave it to the states to make those either, well, they can't make them more liberal, but they can make them tougher. And New Jersey has toughened up the standards above the standards of the Federal Highway Administration. But what happened approximately in 2012, federal government undertook a study because they were being bombarded with digital signs. What they did is they compared the safety aspect of static signs that were in place for a number of years to digital. And with modern technology, they were able to mount, I guess, cameras within the motor vehicles. And they would watch the eye glances of the driver. And the drivers were not told what they were being studied for. So this study was released, it was peer evaluated, and it's been a standard for placement of billboards since 2012. And in my traffic analysis, I included the executive summary of that Federal Highway Administration report in the submission. So that was, the findings of that study were that the glances at a static and a digital billboards were about the same, and it was 0.3 seconds. So if you're traveling at 50 miles an hour, and then you have, which is the speed limit, and then it's about 50 miles an hour is about 75 feet per second. So you travel a certain distance. We evaluated the viewing angles from those distances. And in my report, I presented a graphic that shows that you can see the billboard for about 700 feet. So based on 700 feet, in the eastbound direction is 740 feet, and that visibility is 10 seconds. And in the westbound direction is 825 feet, and that's 12 seconds. So if you have 10 to 12 seconds to view this sign, and the glances that the federal government determined were the standard for viewing billboards was 0.3 seconds. You have plenty of time to view the sign. And then, so what I did is I plotted the viewing angle of the billboard, and I plotted those in my exhibit A, and then I took the 4 to 5 locations where I did the viewing angle, and I posted those pictures to what one can see traveling east and west on Route 4. So it's clear that you have plenty of time to view the sign, which makes it not a hazard. And its design has been properly located. It meets the DOT standards. New Jersey DOT goes out and looks at the sign location, and they'll reject the sign if it's in an improper location that doesn't have adequate sight distance. And obviously this one does, and so that the east and westbound, when you have 10 to 12 seconds to view the sign, and it only takes a third of a second for the glances. It indicates to you that there's no traffic problem in place.
And you signed and sealed this report?
Yes.
And Chairman, I'd like to move this forward and mark it as exhibit evidence as I believe, on 8/12.
So, yeah, let's get the, so if I have from the prior meetings, we were up to, I think, we had 89. You haven't seen.
I believe I thought it was with video. They made a lot of video. I think we're off doing a lot.
Traffic report from Mr. Simoff comprised of 30 pages.
Mark, I have the list of exhibits marked that were posted online.
Yeah.
Okay.
You're at 8/13. This would be 8/12 report. Previously submitted to the board.
Yes, I believe I submitted 18 copies. I submitted 18 copies to this release.
So then we'll make the traffic report for 13. We'll make a video.
The video is up there.
Yeah, but is it long?
Yeah.
It's marked as 8, the video is marked as A10, A11. A11 was marked NJDEP flood hazard applicability determination. A12 is traffic
A12.
report, 6-5.
Ready to go?
Ready, Mark.
Still, turning your attention to the outdoor advertising permit, does the state have an obligation to review billboard applications in order to issue an outdoor advertising permit?
Yes, and it's not only on state highways, it's on local highways. There's an example. I worked on one on River Road in Edgewater, and it was required to get a DOT permit.
Can you please discuss the regulations and procedures in the scope of the state's investigation?
They break it down into two types of highway. It's either a limited access highway like Route 80, where the spacing has to be 1,000 feet apart, or a local road with access, that permits access, and that's 300 feet apart. It can't be, so obviously another billboard within 300 feet would knock this one out. Digital billboards are allowed every 3,000 feet on each side. And while I know in Pennsylvania, digital billboards are not, can be spaced 300 feet compared to New Jersey that requires them to be 3,000 feet. But the federal, they all come from the outline provided by the Highway Beautification Act. Goes with the landscaping and the wildflowers.
Then the applicant has obtained this permit.
The applicant has obtained, and then the other thing is when they come out and they look at the site, they look at the available site distance, because they know that if, there's been some studies that if, in the older material, where you're coming around the corner and you just see the billboard, that is not a safe application. And the DOT would deny that something of drastic means.
And I believe looking at your list was previously marked as a 13 permit.
Yeah, and I think part of the reason I got confused is looking at what's on the website, it looks like the traffic report that it places.
I only did one.
I just put that, it's the same.
It's only there 11, so that is a 12, the traffic report, and then the DOT permit is a 3, I guess it's marked. The previous. No.
And one more thing, the criterion cannot be modified. If you don't meet the black and white, it's a black and white permit. If you don't meet the spacing, they'll deny you even if you're 2 feet short. So in order to get a permit, you have to physically meet all the requirements.
Now, I'm gonna call your attention to the review correspondence of the board engineer, which I believe was revised on July 3rd, 2025. Have you had the opportunity to review that correspondence?
Yes, Mr. Costa.
Yes. Now, with respect to item 13 on page 5, could you please clarify an opinion whether the presence of the surrounding elements, visual obstructions, roadside elements, and adjacent development that may impact driver attention or visibility in combination with the proposed billboard will contribute to a visual clutter or distract in a manner inconsistent with the conclusions of the FHWA study?
Well, I'm not here to suggest that what visual clutter is, that's more planners discussion. But the issue of distraction, it's clear that this is not a distraction. The studies have shown, the FHWA study was done on arterial roads and was also done on freeways. And they found that within the cone of vision of the viewing of the sign, it takes a third of a second to the glances of these billboards were reviewed in 0.33 seconds.
Yeah.
Static.
And with respect to the board planners review correspondence, May 22nd, 2025, have you had the opportunity to review the planners?
Yes.
And now, with respect to item 5, could you please confirm whether there would be adverse impacts of the surrounding roadways and traffic if the billboard was approved?
Absolutely no negative impact.
Now, do you have an opinion as to whether the client's application, if granted, will cause a substantial adverse impact upon traffic operations in the adjacent roadway networks?
It will not. And that's also confirmed by DOT. They wouldn't issue a permit if it created a traffic hazard.
Based upon your study and findings, do you have an opinion as to whether or not the levels of service of adjacent road networks will be negatively impacted in the borough?
The billboard doesn't generate any traffic, except once a month when they come to change the copy. So it wouldn't add any traffic. I couldn't think of any reason why somebody would go out of their way on Route 4 to look at the billboard. So it doesn't add traffic to the traffic flow, and it meets the safety standards of the FHWA report.
Is your opinion that the surrounding properties will not be negatively affected as a result of traffic?
Correct. Yes.
That's all we have from Simone. Questions?
Turn to our planner. Turn.
Okay. Hello, Mr. Simon. Good evening.
What do you think?
Yes, so if you can hear me, I'll just start off with some questions going back to the DOT permitting. So why does DOT regulate billboards in the first place? What are their priorities or goals?
The Highway Beautification Act requires that billboards be regulated. And before the 70s, there was no regulation for billboards. And the Highway Beautification Act came along and it's updated periodically. And
But it's called the Beautification Act. So what are the goals or principles that they're trying to achieve by having regulations?
that you don't get that you regulate the distances between billboards.
Okay.
And the height, I'm sorry, not the height, the square footage. And now they regulate, the state regulates spacing of digital billboards.
Right, and I think in New Jersey, digitals is 2,500 feet, linear feet,
3,000,
it's 3,000, and static is what?
300 on a road that's not limited access. A freeway is 1,000 feet, you know, like Route 80.
Okay,
And Route 4 is 300.
300, okay. Are you aware of any other siting criteria that DOT uses to make their determination other than these linear distances?
Space between ramps.
Okay. So would this exit, which some might call an off-ramp from Route 4, would that be considered a ramp in DOT terminology?
It's not because DOT issued a permit.
Well, let me ask this nicer. Is it possible that could have been overlooked? I guess as a traffic engineer, when you look at that Route 4 appendage marginal road / part of the highway that goes from the highway to River Edge, what would you classify that as?
The service road,
So not a ramp, but a service road.
correct, because it has access. The ramp doesn't have access.
Does DOT consider non-DOT issues, meaning beyond the right of way, issues related to the municipal land use law? I'll ask one at a time. Do they consider any other issues that are non-DOT related outside of the right of way?
Well, traffic safety,
In the DOT right of way?
well, no. Because as I said, I worked on a billboard on River Road in Edgewater.
Yeah.
It's a county road and they require a DOT permit. I think it's within 660 feet of the state highway.
Does, other than traffic on the highway, does DOT consider aesthetic impacts in their permitting?
I don't think so.
Okay. Do they consider the municipal land use law criteria as far as when variance relief might be required? Or site plan criteria?
They require that it be in a commercial zone. The property that's zoned commercial, you know, can't be a residential zone. And then, but that's why they require every application to come before the local board.
Okay. Do they consider any other impacts at all, public impacts or impacts to adjacent privately owned properties?
I don't think so.
Okay. Do they conduct an analysis of other signage in proximity to the site?
Well, you're not allowed to have a sign within 300 feet.
A billboard, but other
Well,
signage,
an off-premise sign.
or on or off premise sign? No, so any signage at all? Do they look at
They don't.
any other signage in proximity?
They don't look at on-premise signs. They're not regulated.
Or highway signs? Do they look at highway signs? How close
Yes.
the billboard is to the highway sign?
If it impacts a highway sign, they won't issue a permit.
Okay. This isn't a gotcha, but I believe what was testified to is that there's about 6 billboards within a half a mile to this site. Traveling at 50 miles per hour, how long does it take to travel a half a mile?
Well.
I
50 miles
can
an hour-
look it up. I'm not trying to get you on it.
50 miles an hour is 73 feet per second.
Okay.
So you do.
I'm not gonna do that, man. Let's assume I had it written down because I didn't want to do the math.
So if you take 2,500 and divide by 73,
Right.
whatever that number comes to.
Making me work tonight, man. Say it's approximately 34 seconds. 36 seconds. 2,500 divided by 73?
Well, 2,500, it would take one that time to traverse
Right.
a mile.
I guess my my thought is, would you, if that's the case where you travel a half a mile within 34 seconds, by the time you've encountered this site, you've seen 6 billboards within 34 seconds. And this would be a 7th billboard to be viewed within that 34 seconds. Is that a fair, does that math make sense?
Yes,
Okay.
but when you're talking about a viewing glance of 0.3 seconds for each billboard.
That's the safety component of it.
Yes.
Okay, that's fair. I'll take your point. Have you considered other signs in the vicinity of this billboard that might compete for attention?
Well, I looked at the out front billboards on the railroad right away,
Okay, so
or to the east.
starting with this site, are there any signs on the building, on the site?
I don't recall.
Okay, there are two, at least one in each direction. Is there a traffic sign that directs drivers to the service road or whatever you refer to it as, that it is within close proximity to the billboard? There is.
There is, okay.
And for argument's sake, there may be a few other signs in the proximity to the site, that could arguably be in the driver's view shed as they, approach the site, at least from, probably in either direction, east or west. So I guess when you do your safety analysis and was it FHWA has their analysis of what, and I think it's an average glance, is that accurate? The 0.335 seconds?
It would be average.
So is one entitled to look at a billboard longer than 0.335 seconds?
Well, they used the maximum in their study of about that. And they found that
It's an average, 0.335 seconds.
the 0.3 was average. But in their study of glances, the maximum was 1 second at any of the billboards.
The maximum but that's for a single sign, 1 second.
Right. And they likened that, there was a study done by the federal government. They called it the 100-car study, where they took 100 cars and looked at what, it was originally prompted to evaluate texting and looking off out of the front window. And so they said that a glance greater than 2 seconds distracted from the roadway is a traffic hazard.
So 2 seconds is the safety threshold.
To look down at your phone.
To look away from the road.
Looking away from the
To
road,
look away from the
change the radio channel,
Okay,
reading a map.
bear with me here. Are you able to address the road classification question as far as service road, marginal road, highway?
Well, the highway is called an urban principal arterial.
So there's the 3-lane component, and then there's this exit off of the highway. Do we know what this exit service road qualifies as? Is it in fact part of the highway?
I would think that it's a service road.
Yeah.
Because if it was a ramp, you're not allowed to have driveways on a ramp.
Okay. Bear with me. Have you looked at any accident data for this segment of the highway?
No.
Okay. As far as the glance issue, phrase this as a question, are billboards created differently to the extent that, and I'm not delving into content, but as far as the messaging, that some messages could be longer than others? Is that
Of course,
a
yeah.
fair assumption? So is it possible that it might take longer to digest one sign of a certain length versus another? Just from a time perspective, forget what it says.
Well, what the study found is that if the copy was too much, they just looked at it for 0.3 seconds and traveled on.
Final question is, are you aware of any billboard industry advertising information that indicates that they prefer you to look at their signs more than 0.335 seconds?
No, I'm not aware.
That's all I have. Thank you.
Okay, we can start with, Williams and Alva.
No questions.
Jody?
Yes, I have a question. The DOT permit states that the location is 30 feet west of Grand Ave. Whereas in that picture, it looks like it would be north of Grand.
Well, sometimes they're not the best at getting east orientation of east and west. But
What? If that was incorrect and it wasn't 30 feet west of Grand Avenue, wouldn't that invalidate the DOT permit?
well, the plan is also submitted to the DOT.
If I could just jump in a little bit, I think part of the confusion, maybe I'm wrong, I'm just looking at Google Earth, but the Grand Avenue seems to be, two routes, the road to the south and the road to the west. So that's, they're both Grand Avenue.
Okay.
That makes it very confusing.
Got it.
But I thought we had a testimony before that that portion wasn't Grand Avenue, just the other road is Grand Avenue.
We can go out and do the street signs, let me just show you what.
No, I'm looking at the same thing.
It says Grand on both, right?
That wasn't the testimony earlier today, that's what I'm saying.
Yeah.
But
Well,
so
so.
a location
north-
map is submitted as part of the DOT application.
But even if it's like that, the one side it would be north, the other side it would be east, no?
North is up.
Right.
Yeah.
So to the right is east, so even if we're talking about the other part of Grand, wouldn't it be east, not west? And if the location on the, again, my question is if the location is incorrect on the DOT permit, wouldn't that invalidate the DOT permit?
They allow if, as long as you don't violate any of the other criteria, if, as an example, if a board says, we'll give you the approval, you have to move it 10 feet in another direction, you resubmit to the DOT and they'll reissue the permit.
So you would have to resubmit this.
If it's not accurately located in the DOT permit.
I think we're gonna need clarification on that.
So I have the permit, sorry, I can just interject.
If you could use the microphone,
Oh,
sorry. And board members too.
Sure, the DOT permit, states, 30 feet west of Grand Avenue. The DOT is not considering the service road, Grand Avenue. Grand Avenue is your municipal right of way. So our sign is located 30 feet west of Grand Avenue. That's.
Earlier, that was north when you were testifying. You showed us to the north, that's up top, that's north. So what you're pointing at now is west, was north earlier on in your testimony.
But Route 4 runs east and west.
Right, so it's north of Route 4, not west.
That's how the DOT, I understand.
We're talking about Grand Avenue, not Route 4.
Grand Avenue is the municipal right of way. This is the service road of Route 4. The DOT is not recognizing anything within the right of way as Grand Avenue. This is a municipal roadway.
Right.
This is where they're locating 30 feet west. This is the west direction of Route 4. This is west on the plan, west on the map. We are 30 feet west of the intersection of Grand Avenue.
Where's the key there?
I'm sorry?
Where's the key?
Where's
The key that says northwest, east.
Oh, sure, it's on the overall, down in the right-hand corner. So it's north,
Which, I'm sorry, which exhibit was that?
this is A6. A6 or A5, I think was the other aerial. They're both identical. You get A5, same thing. The north arrows is oriented in the same as the point. So it's 30 feet west of Grand Avenue as it intersects the state highway.
No, I mean,
They
I'm seeing it differently. It looks like the red arrow goes north and that's north.
They don't
30 feet
really
north.
get more specific than that. There is a diagram that they usually have as part of the permit. We can probably produce that for.
That's fine. As I said, we just wanted more clarity on it.
Sure.
That's all.
No, I chimed in. I'm good, thanks.
Rick? Yeah, I, question, when you're talking about kind of development, this says oriented to the sun. But I guess one of the circumstances that turned to that is when there are people changing the sign, which is things happening. I think it's a little different. I mean, I'm sure everybody in this room is learning to filter out billboard signs and highway signs. I mean,
Unfortunately for the client.
exactly, but I mean, and so, everybody learns to not see it, right? And it's a different trigger when you see bodies moving around the lights. Okay, you're gonna look at that. Okay? You're gonna look at that kind of at the worst possible moment where the other Grand Avenue comes down and hits the Grand Avenue there, but that will not be visible right till they get to nearby. And people coming off the highway from down the ramp, got people coming down Grand Avenue. And you're gonna see that person or persons doing maintenance and or changing signage and whatever they're doing. I think that's a very different condition than I'm driving down the highway with the billboard outside of me. It's right out of me. Instead of learning that people coming off the highway, or people are accelerating to go onto the highway. I guess I just like to hear your comment.
Well, I don't know if any studies have been done as to, what happens, what kind of glances are promulgated by changing the copy. But if this board was inclined to approve it, I could imagine that they could limit the time of day when the copy could be changed. If that's one of the concerns. I've never heard of that concern. But one way to address that is to say when the traffic volumes are less, say in the middle of the day, you could find a window so when they can change copy.
I'm not sure it's because of the data.
I think it's the same thing.
But I guess,
But it's a fact of life that you have, that you change the copy. Some, some places it's more than a month. So if they're talking about a half hour or an hour during the month, that's a very small percentage.
understood, but if, the criteria for safe positioning is based on that 30% position, and we know, or at least I'm reasonably convinced, would draw people's attention, especially again, in a critical area of merging, and speed.
Well, there's a concept of traffic engineering or load shedding. So what you do is you focus on the driver focuses on the critical aspects like the car in front of them. And then they branch, and then there are lower classifications of distraction. A tree on the side of the road, that would be much lower in the hierarchy. So you focus on when the traffic volumes get high, as they are on the floor, you focus on drivers have a tendency to focus on the activity in front of them and then load shed other aspects of driving past.
Understood. And again, the static signs, things that I expect. Sure, I trained myself to do exactly what you just said.
And that was something unexpected, there were people climbing around 50 feet in the air. That's not what I'm expecting to see, and that's what raised that. Oh, I just, again, it just creates.
I have to confess, no bad in the study.
Not too many intersections, but. You've got. On the service road, the highway ramp, who knows what it is, but you do know that. Henson, and there's a lot of people jockeying for position, and a lot of people moving at speed. Highway, it's already there. Yeah, I think the situation is a little more, has a little more potential problem than I've got a highway side on side road, I'm doing 60 miles an hour. Which is a difference.
Well, and the other thing is, the closer you get to the sign, you get out of the viewing angle. The viewing angle that this study determined was 40 degrees. And it was about 40 or 50 degrees. It was 40 degrees laterally and about 40 or 50 degrees horizontally. So as you get closer to the sun, you don't look up. You see the sun. You don't see the sun because and it's plotted on my drawing in the lateral condition. I didn't look at it horizontal.
All right, thank you.
Good.
So, big concern that I have is along with Mr. Craig, but you're coming off a highway. You've got Grand Avenue coming from your right. You've got now a new sign that you probably didn't see because you're getting off the highway, so you're not doing 50 miles an hour, you're doing 25 to 30, 40 miles an hour. And then you also have a bus stop directly past the sign. When you look at Google Earth, I don't know if that's the Jitney spot. And you get a lot of traffic coming off that highway. You get a lot of people on Grand Avenue, especially 5, 6 o'clock at night, especially this time of year. You know, the liquor store starts getting a little busier. I'm concerned of someone coming off the highway, having Grand Avenue, slowing down, having a bus stopping in front of them, and having a billboard right in their face.
Well, the one point is that if you go from 50 to 25, you double the availability of this. You're no longer 70, no longer 10 seconds. You're in view for 20 seconds. And then the other thing is that the lateral, the horizontal viewing of the angle, you can't see it until when you get closer to it because it's high. You know, that's one of the advantages of making it higher. You can't see it as you get closer to it. But the bottom line is DOT looks at, there's an overhead sign on Route 4 that's in the pictures. The DOT looks at that. You know, they won't let a sign, they won't let a billboard impede on the visibility of an overhead sign on the highway. And they look at the other regulation signs that they control for the ingress and egress of the highway. And if it conflicts with the safety of the operation of the ramp, they won't approve it.
I don't see you having an issue seeing that sign. I don't think you have an issue seeing the exit sign or anything. But again, you've got a lot going on there, and I said 25 to 30, but I don't think any of us are really doing 25 to 30 coming off that highway, unless there's traffic. You know, you're still coming off at speed, you're coming through there, and now you've got multiple distractions. And to go back to Mr. Barron's line of questioning with what could be 7 signs in a half a mile, you could be seeing seven signs in a half a mile. Now, I'm not gonna go with the average, I'm gonna go with the worst case scenario, the person that looks at it for a second. So they're spending 7 seconds out of that 30, whatever, looking at a sign. And they're also looking at their phone, they're looking at the GPS on their dashboard, they're looking at all the other screens. You said that distraction thing was done in 2012?
The report was originally written in 2000.
2012-ish, 2011, 12.
So, yeah, that's the order. But what happened is it was peer reviewed, so they didn't release it until like 4 or 5.
That's fine. Where I'm going with it is my car in 2012 didn't have a screen in it. Now it's got a big old screen in it. So it's another distraction. I think that we're,
But basically what the study does, let me make it a little simplistic. If you're looking out the front windshield, you're within the viewing angle of the sign. They looked at, you don't turn your head and look out the side window of the sign. The angle of viewing is basically the front windshield of the car. And I don't think that the GPS or some of the other aspects would change that concept.
it changes the distraction for you. And, you know, we've got a lot of problems with people being distracted. And now we're adding a humongous distraction, 60/14. At a spot where you're getting off the highway, where you have another street coming in, where you have a very popular, you know, liquor store, CVS, you know, type establishment, and a bus stop. All in a very small period of time after you've seen 6 signs in a half a mile. So I just think it could create, you know, and I'm just looking at the getting off the highway, let alone people that are still doing 50 to 60 miles an hour on the highway. So I'm concerned that it's gonna cause, and again, I get you're saying you're getting closer, you're not looking at it. But if I'm getting off and that's my first chance to see it, I could be looking up and making it easier. I'm concerned with having more accidents on that service road and on the highway because of.
Well, I've done some studies before and after a billboard placement, and I found that the accident rate doesn't change.
But I think this is still a unique
I did
spot where it's
run
happening.
originally to a union. With billboard in the center island. And I did 3 years before, 3 years after the place of the existing billboard. It showed no change in the accident rate.
I'm still concerned with 57. So, you know, and again, with new distractions, with people looking less in front of them than they are, you know, paying attention.
I hear what you're saying, but the statistics and the reports that have been issued don't bear that out.
I don't think I had any other questions, right?
Thank you. What consideration, if any, has been given to the effect of shadows created by the sign on traffic safety in that particular area?
I don't think there has to be.
Oh, I am, thank you.
Paul?
Nothing additional. No.
I have a few questions for you.
Oh, sure.
So I'm gonna look at your exhibit A in your report.
Yes,
Good question. Did your report take into account the approach from Johnson Avenue coming onto eastbound Route 4? Any impact of that location? The Johnson Avenue is on the south side of Route 4. So is there any impact on traffic trying to navigate onto the service road at Route 4 and then onto the?
no, because it's beyond the view of the sun.
Did your report take into account the eastbound flow of Grand Avenue over by the Total Wine Building? You familiar with that location?
That is also beyond. No, it's not beyond.
Did you,
I have number 6.
well, no, I'm looking at the Grand Avenue. The Grand Avenue is a two-way traffic flow by the Total Wine, where Beaufort Road and Main Street come together. Right?
Yes,
It's, if you look, if number 1 it's above number 1, but maybe the general location.
So it's above, right above the number 1.
Correct, Grand
He was
Avenue
looking
there.
at it.
I was looking at the other Grand
Yeah.
Avenue.
So you have labeled Grand Avenue there. So Grand Avenue is two-way We're flowing there.
where
and-
Grand Avenue meets Main Street.
Correct. And traffic flow is obligated to make a left turn off on Main Street. So did your study take into account the impact of that location? Because you've got competing traffic flow coming off Main Street and coming off the Route 4 service road toward you.
That's probably beyond the limit of viewing of the sun. Picture number 1 is the limit, how close, once you get closer to the sign from number 1, it falls out of visibility. Falls out of the angle of visibility, and
Even though you're at a different angle, because you're not, that Route 1, your label number 1 is actually the Route 4 right of way. I'm talking about the Grand Avenue right of way.
it's, I don't think again, it's beyond the. When you're going from Grand Avenue, making a left on the Main Street,
Correct.
you're not gonna be distracted by the sun. Because, number 1, the sign is 60 feet high, or, 48 feet high. The bottom, up 60, approximately. It's beyond the visibility of motorists.
And with respect to, I'm gonna shift back over to Route 4 westbound. So did your study take into account the acceleration and deceleration aspects or the exit ramp for Grand Avenue there?
Like
where Hackensack Avenue accesses Route 4 west. So this would be to the east of your label number 9. Did your study take into account the competing traffic flow between traffic trying to exit and traffic trying to enter the roadway? And the grade
beyond location number 9. I guess it's east of 9. You can't see the sun.
Well, hold on. So east of 9, you have traffic coming on from Hackensack Avenue coming out of Riverside Mall. That's trying to get on westbound Route 4.
Yes.
Okay, so that's an acceleration lane. Then you have traffic traveling westbound on Route 4 trying to exit at Grand Avenue. They're decelerating. Did your study take into account that conflict in the traffic and the safety of that area and the people be distracted by the billboard?
No, because it falls out of visibility.
How's it fall on visibility?
Visibility is 40 degrees.
Okay, even with the grade change there?
Well, and also the height. It falls out of visibility, the height.
And it's your testimony that the billboard sign does not conflict with the roadway signage at number 6?
Correct.
Okay,
And the DOT has confirmed that.
okay,
Like this, as you go to the east of number 1, there's an overhead sign. If this billboard conflicted with that sign, they wouldn't approve it.
okay. And is your findings at that point, just the basis of DOT's determination, or did you come to that finding on your own analysis?
Well, I agree with the DOT.
Okay, to the injectors, Mr. Sarlo, we'll start with you.
Thank you, Mr. Chairman. Good evening, Mr. Snow.
Good evening.
Few questions for you. The USDOT report that you referenced in your report, I think you provided a executive summary of that report. That's dated, 2015.
September 2012.
Well, okay. Has there been any, amendments to that report since 2012? It's over 10 years old.
Well, as I said, this report was written in 2012, but it was peer reviewed. It took like 3 or 4 years to be peer reviewed. So it was released about 4 or 5 years ago. I'm not aware of any updated studies.
So big studies. Okay. Are there any other studies out there that talk about the timing aspect?
This took into account, there were many studies done, like Virginia Tech did some studies. Then there was an anti-billboard group that did some studies. And this report considers all those previous studies and critiques them and gives them credit where they do agree with. And then they issued this, and then they opened it for peer review. So it took 3, 4, 5 years of peer review before they finally released this study, although it had a 2012 date.
Are there any peer reviews out there that are critical of the findings of this report?
Yes. Not everybody, the anti-billboard people still think that billboards are unsafe.
Did the USDOT report that you referenced, and it's all relevant because you used the 0.33 feet, right? 0.33 second.
Well, that's what they found in their study.
Right, and that was part of your testimony, right?
Yes.
This group for the safe because that 12 seconds, I think you said, versus the 0.33.
No, you're available for 11 to 12 seconds. But the 0.33 was the glance.
Right. So the USDOT report consider the criteria or variables such as intensity of the billboard,
Yes,
billboard size,
yes,
billboard proximity to the travel lane,
yes,
length of the message,
no,
complexity of the message,
no,
size and font of the message characters,
no,
proximity to the traffic control devices,
yes,
proximity to roadway geometric design features,
yes,
proximity to other billboards,
yes,
complexity of the environment in which the billboard is located,
yes.
traffic and speed,
Well, they broke it down into arterial and freeways. So, but they didn't differentiate the spacing distance like New Jersey DOT does.
and traffic density.
Yes, they looked at level of service.
So he answered some to the criteria, some no to the criteria. So how does that relate? The study was done on highways in Virginia, I think you mentioned.
No, it was done in Reading, Pennsylvania, and Richmond, Virginia.
So how do those highways relate to Route 4 highway?
Well, the studies were done to evaluate, they mounted it in cars to evaluate the glance timing. And then they used that glance timing as the basis of their study.
Right, but we went through a number of criterias and variables, and you answered that the study did not take into account some of them. Some of them are relevant to the subject area that we're talking about. How can you
Well,
conclude that the 0.33 is valid?
Because they gave a range and they accept, there's nobody that's gonna tell you what you can put, once you approve a billboard, what you can put on that billboard.
Okay. You wrote, you worked at the report that was submitted dated June 5th, 2025.
Yes,
I'd like to point to page 4, the last sentence on page 4. Can you read the last sentence for me?
The goal for the placement of proposed sign is to provide a safe time for optimum visibility to maximize time that the driver will be able to view the billboard.
So, based on that statement, that was the entire goal of your study, was to maximize the visibility and the time someone can look at the billboard and not take into consideration any other factors.
No, I think I stated in my direct testimony that if you place a billboard where there's not adequate time to see it, that it creates a traffic safety hazard.
Well, I'm reading your report.
It may
You
be,
what you state a single goal of your report for the benefit of the billboard, to maximize the visibility and the time the driver will look at it. Is that what that last sentence says?
yes, it may have been worded,
No. I'll answer the question. Is that what it says?
yes,
Is there any other goals in your study? In your report? You know, master plan lists a bunch of goals and objectives. 1, 2, 3, 5, 6, 7, 10 sometimes.
this analysis was to evaluate whether the placement of the sign was safe and in conformance with accepted engineering criteria.
But that's not what your report says. It says the goal was for the benefit of the billboard, maximize visibility and optimal time.
If I may correct, if I may correct the wording, it's to evaluate whether there's optimum visibility and to maximize the sign visibility to create a safe environment.
You didn't correct you didn't correct your report on direct testimony, did you?
I think I did. I think I talked about the availability of the availability of visibility of the sign as to whether placement is in conformance with the federal highway study.
I have no further questions. Thank you. So, there, Katie?
You testified, you testified, you signed the report, the traffic report, correct?
Yes,
Can you identify that your signature on the traffic report?
that's mine.
The one that's pulled up online, I do not see the one that was submitted. Just.
Yeah, I think the one that's online, actually, I didn't see a signature on it either. I saw a signature online, but I don't see a signature.
You said I need US DOT was what, 0.33 seconds per sign, correct?
That's the average glance.
Does the presence of multiple signs impact that time?
No,
Okay, so the presence of 2 signs does not, or 3 signs does not add to that.
correct,
It's not additive or multiplicative.
correct.
Does the 0.335 second glance time also apply to drivers in parking lots?
Well, if you have a billboard in a parking lot, it's visible. But it was done for off-premise signs.
So what is your answer there?
I don't know.
Is the risk of distraction greater in parking lots on the roads or highways?
I would think that highway is more the higher distraction level.
So the sign will not interfere with operations of traffic in the nearby commercial plaza,
Correct.
not with individuals backing out if they glance for 0.335 seconds.
Well, if they're only going if they're going 5 miles per hour, you have a lot of time to view the car backing out of the parking.
But there's several more cars in the parking lot than there would be as much dense, correct?
No, not necessarily.
If the sign is lit at night, is it more likely to, are drivers more likely to be distracted?
No, in fact, the study found that the glance time was less at night.
Is that true? Sorry, let me rephrase that. You mentioned height as a factor for reducing the glance of the visibility angle. Is that true at night as well?
Yes,
So at night, that does not make them more likely to look up at the billboard.
correct.
So the US DOT report data is from 2012, correct, or before, correct?
2012, September.
So the report data is from it. And I asked because you mentioned the peer review, but the peer review would not change the underlying data, correct?
I don't know what happened. I can't tell you what happened before 2012, but I do know that this report was not released to the public until like 2020. It took 4, 5, 6 years to gather peer review, evaluate the peer review, and decide whether it was legitimate or not. Because this was a standard that the Federal Highway Administration was going to put forward for their standards of the Highway Unification Act.
But that would not impact the age of the underlying data.
No, the glance angle is going to be the same whether you do it in 2010 or you do it in 2020.
Is that true? I mean, is there not more SUVs on the road more than ever?
They did it in a Jeep, an SUV.
So that angle was based on one vehicle?
No, it was based on the viewing angle of the sun.
Well, I asked because you said
No,
done in a Jeep.
no, in the report, they show a picture of one of the cars that they used to set up the,
I did see you scroll by the red vehicle. Point that.
there it is. Shows the eye tracking system camera placement in a Jeep.
Okay, but would you agree there are more SUVs on the road than there were in 2012?
I don't know.
Would you agree there are less sedans on the road now than there were in 2012?
Well, they use an SUV to do the tracking.
Well, I'm asking about the average car,
I don't think it makes a difference.
not for the viewing height or the angle.
The difference in the viewing height of a couple feet being higher, I don't think would affect the angle of the viewing, either horizontally or lateral.
Can you read the final paragraph of the executive summary of the DOT study for me? It's page 4.
What do you want me to read?
Final paragraph.
It also be noted that like other studies in the available literature, the study adds the knowledge base on the issues examined. It does not present definitive answers to research questions investigated.
No further questions. Thank you.
Thank you, Mr. Chang. Any members of the public wishing to make comment?
All right, no more questions, I think. All right, we will call our final witness on planner.
Where Brooks also, you built your, yes, I do.
Could you please state your name for the record?
John McDonough,
And can you please state your profession?
a professional planner,
And how long have you practiced planning?
40 years.
Can you give us a brief summary of your educational background?
Sure, I'm a licensed professional planner in the state of New Jersey. My education comes from Rutgers, and my license is current and in good standing.
Do you know what your license number is?
5189.
And
on Hearst.
have you been qualified as a planning expert to appear and present testimony on behalf of your client before land use boards in the state of New Jersey?
Yes, I have.
Have you ever been before this board before?
Don't know. I don't know if I have. I've been in most, but I don't remember this one.
I offer Mr. McDonough as an expert in planning and ask that you accept his qualifications.
Questions from the board as to Mr. McDonough's qualifications? Being none,
Okay,
proceed.
so McDonough, what was your scope of engagement with respect to this project?
So we were commissioned to conduct a standard planning analysis in connection with the application. Basically 3 parts: review existing proposed conditions, review the relief that the applicant is seeking, the zoning considerations, and then, of course, apply the statutory criteria for the relief that the applicant is seeking.
In undertaking this engagement, what material did you consult to prepare for tonight's meeting?
We went through your master plan documents, you get a sense of your underlying policy documents, and of course, scrub your zoning ordinance as well. We're here in your C2 zone, and we wanted to see what this applicant could do with this land and what's permitted in C2 zone.
So to be clear, you went through the master plan and the zoning to,
Yes, that's fundamental to our analysis.
Now, could you please describe the project as you understand it?
Sure, so this is a billboard application on a developed piece of property. It is a single tax lot, lot 1405, lot number 4. It's about 18,596 square feet. And it's developed with, as you're now familiar, that multi-story office building and parking with some green space, which is where this monopole structure is going to be positioned. It is, again, cantilevered structure. The permit is for a single sign with a double face from the NJDOT. That's the way the DOT classifies these as 1 sign, not 2. And it's going to measure 14 by 48 for each of the panels, which is 672 square feet. It is going to rise up to its highest point at 60 feet above the grade level, or AGL, again, to provide that clearance over the building that it will cantilever over.
And have you physically inspected the property yourself?
Yes,
And are you familiar with the surrounding area?
yes, I am.
And I believe you may have testified to this, but where is precisely the property?
So we are in the extreme southern portion of your property, along the highest order roadway in your community. Our land use patterns follow our transportation patterns. The applicant did not put Route 4 there, it's there, and again, this is a land use that follows that particular transportation element.
And could you please identify the specific variance the applicant is seeking in connection with this application?
Before I do, I want to point out that in your community, if you look beyond the subject site, if you go north, you're essentially looking at an ocean of homes. Your master plan describes it as a residential community. You have 3,400 parcels here in your community, and 96% of them are residential. So locating this land use on a non-residential parcel in your community has limited location, and this goes towards site suitability. Locating along a arterial roadway or a main roadway in a non-residential area is what this land use, this establishment does.
And now, what variances is the applicant seeking?
So we've got two D1 variances that were noted here. The first is a use variance for billboards not permitted in any zone district in the community. Again, this is what this business does is construct billboards for the public. There's no location where this is permitted in the zone, so of course the focus is on what would most be appropriate from a state permitting standpoint, a non-residential zone. So if we went to that other 95% of the community, we wouldn't even be here because we wouldn't get a permit. So we're located in those, that small pocket of non-residential lots along the highway. Likewise, we've got D1 relief for a number of principal uses on a single lot. 2 is what's proposed. You've got the office component and you've got the billboard component. 1 is what's allowed on a property, and there's no interference with either use on this particular piece of property. There is a section in your ordinance which I was trying to interpret and get a handle on under 416-18, where if you assemble enough land, you could actually have 2 uses on one property in the C2 zone. But this site does not have enough land area to accommodate that. You also have D6 height relief, 60 feet where 35 is the maximum allowed. It's also inherent to the use for visibility and readability purposes. Again, that same 416-18 would allow buildings this tall, if I'm reading the regulations right, it's 12 stories. Again, if you aggregate the assemblage of land there. Honestly, I couldn't find where that could happen, but that's what the regulations said. Those are the 3 Ds, and then you've got C relief for the lot coverage, 95.5% versus 80%, which is a slight uptick over existing. 95.4% is what exists. Again, that's to achieve the pole structure in that grass area. Relief on 3 sides, the front setback, 10.78, where 30 is the minimum that's required. This is not a building. It doesn't have any sides on the structure. It is elevated. It fits within the context of the site in that grass pad. Likewise, we have relief for the side setback at 10 feet, where 15 would be the minimum that's required. Similar basis for relief as the front setback, and then the rear setback at 17.86, where 20 feet would be the minimum that's required.
Now, in the far lines of your profession, applicants seeking variance relief is required to demonstrate satisfaction on the NLUL positive and negative criteria, am I correct?
That is correct.
And what is meant by the positive criteria?
Generally, like any decision that we make in life, you look at the pros and the cons. Positive criteria is essentially to look at the public benefits, the promotion of the public good that would come out of this application or out of any development application. The way the statute reads is we look at the site suitability, or that the site promotes the general welfare because it is particularly suited for the use.
And what constitute the negative criteria?
So the negative criteria is the flip side of that. We typically look for absence of negative impacts, and a conclusion that relief would be granted without substantial impact to the public, without substantial detriment to the public, or without substantial impairment to the intent and purpose of your zone plan.
And when an applicant is seeking variant relief, what standards for D1?
For the D1, that's the highest order of proof. That's where we're looking at again, the site suitability aspect and the promotion of special reasons, which would tie to our land use law, purposes of zoning at the preamble to the statute.
And then the C variances required.
The C variances, you've got 2 options there. One is what we call the C1 hardship, which is the older standard, where it's the applicant's burden to show that there's some hardship or practical difficulty related to the physical characteristic of the land, the size, the shape, the topography, or some other unusual feature that creates a practical difficulty for an otherwise ordinary structure in the landscape.
Now, is it accurate also to state that special reasons are not defined in the MLUL?
I also want to just point out, there's also the C2 balancing criteria, which we typically don't see when we go outside of New Jersey and testify. Somewhat unique to New Jersey, where We apply balancing, again, coming back to the pros and cons. You look at the benefits of the application as a whole. You outweigh them, or you balance them to see if they substantially outweigh, and those negative impacts.
And is the term special reasons, defined in the MLUL?
It's not defined in the MLUL per se.
And generally what are some examples of special?
Well, special reasons come out of the Medici case, which is really the benchmark case for what you all are being asked to evaluate here, D1 variance. And there the court said special reasons can be found in those purposes of zoning. NJSA 40:55D-2, and there are about 18 purposes of zoning, going from A down to P, I think.
And based on the Medici decision, how does that guide an applicant seeking a use variance to meet the burden of proof?
Well, the burden of proof on an applicant, again, is to show that purpose A is advanced here, the promotion of the general welfare, because the site is particularly suitable for the use. The applicant can also demonstrate that one or more other purposes of zoning are advanced as well.
Is it fair to say that generally under the New Jersey land use jurisprudence, each of the proposed zoning listed in the MLUL section 2 may support an application for a D use variance?
Yes, those are those purposes A through P that I just spoke about.
Is it also fair to say that the Supreme Court in Medici has singled out the promotion of the general welfare in the MLU section 2A as one of the most that clearly exemplifies the meanings of a special reason?
Yes.
What is meant by the site suitability test when evaluating whether an applicant is entitled to a D variance?
Well, that takes us back to what I was talking about particular suitability, where the case law tells us to look at the physical characteristics of this property or a property and why it lends itself to a particular use.
Is there any other test or standard that an applicant seeking a commercial or property use must demonstrate? Variance use.
Could you just say that again?
Is there any other test or standard that an applicant seeking a commercial or profit use variance must demonstrate?
I think you've hit the cases.
Are you familiar with the decision in Polio v. North Brunswick?
Yes.
Am I correct that based on the holding of that case, typically a C variance is subsumed with the D variance request?
Yes. I think the board, you're faced with 6 variances here. You've got the 3D, including the use variance. You've got 3 Cs. Basically what that Paleo case said is you can really, to help you, is consider the application as one package or one bucket of relief here. In other words, you may find that the use is appropriate, but the setback is not. But here, in this instance, they're all really tied together. One goes with the other. We can certainly talk about that height there, but I would also fold that into as inherent to the nature of the use.
Now, in accepting and undertaking this project, please inform the board as to your findings, reaching conclusions you have made to evaluate whether the applicant satisfies the positive and negative criteria required to obtain the variance through.
Well, in terms of the positives and special reasons, the use is what I would consider a message board that promotes the general welfare as a form of communication. Our courts have made clear that this is a form of constitutional free speech. It's the way we talk to each other and communicate to each other. There's some case law out there known as the Bell versus Stafford case, which talks about commercial or constitutional free speech. I think it's self-evident that the use promotes business. It's an advertising tool. It's a way that businesses get the word out. These are companies that we work for. These are companies that we work with. These are companies that we may invest our nest eggs in. The use also goes outside of business and may also promote institutional type uses, which may be considered inherently beneficial uses. And usually when I say that, people say you're not promoting this as an inherently beneficial use, which I'm not. But hospitals, churches, schools, educational uses, colleges and the like may be considered inherently beneficial uses. And we see their branding or their utilization of this as a tool as well to speak to the public. The use can also provide public service announcements. That's typically more when we're dealing with digital display, but that's certainly not preempted here as well.
So in terms of special reasons, all of those purposes that I just gave you would certainly promote purpose A, the promotion of the general welfare. Again, promoting business, which actually comes from the New Jersey Outdoor Advertising Regulations, which recognizes the need to strike a balance here, stimulate economic development, and of course, questions that you all have been asking, impacts on the public and the surrounding area. So it's a balancing as all land use is. In addition to purpose A, we look at purpose G, the provision for a variety of uses in appropriate locations according to the needs of all New Jersey citizens. This goes back to site suitability. The highway's there, the applicant didn't put it there. The applicant has to, under the state outdoor advertising permits, be within a certain proximity of the highway. And we think the applicant has picked a good location that has minimal impact on the surrounding properties. I know we'll probably have questions about that as we go. But my conclusion in that regard is based on the orientation of the billboards. I think our neighboring land uses will see mostly the back of the board, not the advertisements. And those across the street will see what I'll call the nose of the sign. The panels face out towards the highway, towards the motoring public, and that's where it's intended to be. When we get there, I can tell you what DOT says about your safety concerns, which are legitimate and good, but I'll give you the words of DOT when we get there. Also, site suitability on the positive side, the site is particularly, I gave you purpose A, I gave you purpose G. I think we can also throw in there through Mr. Simoff's testimony, the promotion of the free flow of traffic, that this will not create a negative traffic distraction here. That would be purpose purpose H, free flow of traffic. There's nothing about this location that is going to interfere with circulation on site or circulation on the roadway as well. Again, using that traffic testimony as a predicate for my testimony. And then lastly, we have a planning goal to use land efficiently, purpose M under the land use law. Here we have a site that's developed. We have a pocket on the site where we're confident that we can put this sign without interfering anything that's happening on the ground. We don't have to take down any trees. We don't have to clear cut a site. We're not eliminating a forest. So again, that's efficient use of land. It's repurposing a portion of the site in, I think, a minimal way on the ground. And again, not interfering with the use, the flow, the function of the site itself. So purposes A, G, H, and M are things that I think the board can find a nexus with. And also in terms of site suitability on the positive side, the site is particularly suited for the use by virtue of its context. It's one of only a handful of lots that are actually on the highway, on the transportation artery. And the site is particularly suited by virtue of its condition. This is an easy on-site retrofit. Again, we're not moving pieces around to make this work. And then perhaps most importantly, these are strict rules by DEP. These permits are not handed out willy-nilly. There are a lot of spatial controls here. That said, DOT has found that this particular location is what is defined in the regulations as a permitted location as defined by the rules, and it has issued a permit in that regard. Just to cite some of the regulations again, and this will go more towards the negative criteria. These come right out of the outdoor advertising regulations in terms of restrictions, 16:41 C-3.1. Subsection D, no outdoor advertising sign shall interfere with the ability of the operator of a motor vehicle to have a clear and unobstructed view of streets or highways ahead, approaching, merging, or intersecting traffic, or official signals, signs, or traffic control devices. E, no outdoor advertising sign shall interfere with or contain advertisements that resemble any official traffic sign, signal, or device. G, no outdoor advertising sign shall be of a type, size, or character or placed at a location that will endanger or injure public safety, or health, or pose a physical threat to property in the vicinity thereof. These are all the underlying rules that
the DOT has to consider in terms of issuing this permit. H, no outdoor advertising sign shall advertise any activities that are illegal under federal law. I, no outdoor advertising sign shall have any animated or moving parts or have reflective materials that may impair the vision of a motorist. The components of a mechanical sign, that's not here, so I won't go into that. No outdoor this is L, no outdoor advertising sign shall be located on a scenic corridor or with any protected zone of a scenic corridor. Route 4 is not a scenic corridor, that's all I can say. Garden State Parkway is, that's why you don't see billboards there. So there's no prohibition under L from a DOT standpoint. That goes towards positive criteria, site suitability.
And then do you have any comments on the public impacts of this?
So the use is functionally inert. Suffice it to say, we're here in the C2 zone. I know we have a neighbor that's concerned about impacts on the rooftop and the privacy of the use, the enjoyment of that space. There are a lot of things that could go here, including another office building with another rooftop right next door. So there are also about 21 or so uses that could go in the C2 zone. You nest all of your C1 zoning allowances and they're all the usual retail and commercial uses that are associated with a commercial highway. So you would certainly get a lot more functional activity, intensity of use than a stationary sign on the site that does not promote any traffic, does not generate any noise, does not generate any waste, doesn't need any water, doesn't need any sewer. So it's sort of a passive use in that regard. If it really comes down to anything, it would be the visual impact, and we'll talk about that as well. With respect to visual impact, as I said before, the back of the sign faces the neighboring property owners, so we don't have the distraction of the content or the copy. The nose faces the properties on the opposite side of the street, and then again aimed at the motoring public, where we have a pedestrian bridge right there. I think somebody had a good question about movement, and I thought that was good when it's the first time we heard that in one of these hearings, but we do have movement going across the highway. You have sidewalks there, so people are inherent to the area and the movement of people as well. So I think that goes towards the filtering, that we all filter these type of things. And I think there was an agreement to put some sort of reasonable restriction on when men could be up there doing what they were doing in that video.
And the applicant will agree. Restriction on. Change the messaging.
Yes. You have good predicate testimony about the lighting levels, the brightness. We hear that a lot about with these types of signs, and I think the applicant has given you good evidence in that regard to build a planning conclusion that this will not create a substantially adverse impact from an illumination standpoint. You've got the good predicate testimony from a driver distraction standpoint. The national studies, the USDOT, the Tempella study, the Virginia Tech study, and then, of course, Mr. Simoff's site-specific testimony as well. So based on all of that, I think the first prong of the negative criteria can be met here, and that relief can be granted without substantial detriment to the public. There's a second prong to the negative criteria about whether the relief will cause substantial impairment to the intent of your zone plan. That's when we turn to the master plan. I know I'm going to get asked about that, but you do have goal number 8 in your 2020 master plan reexamination report that recognizes the need to maintain diversity in non-residential uses and in your non-residential zones. This does provide that. And again, it's a use that belongs somewhere. We think the applicant has found a reasonable location in the context of the landscape. And if you look at your town, this road is at the very bottom of the town, the very southern portion of the town, a relatively short length. So our applicant doesn't have a lot of other options than in this cluster of lots here. I don't think there's really a much better location along the corridor. If we move to the left, I think that would be to the east. We're moving closer to residential uses that start to move into the highway. Likewise, if we start to move in the other direction as well. So here's an area where we do have a nice cluster or a nice pocket of commercial uses. The use is less intense and less impactful than the many other uses that are permitted in the zone, and it has significantly less mass than bulkier buildings that could be allowed here. As far as the master plan goes, we do have the encouragement of economic development. This is a rateable, it's a commerce-oriented zone, and this is a commerce-oriented use, so it does promote economic development. That goes towards the first D1. Second D1? Okay, second D1, sort of a more simpler proof here. This is to have two uses on one property. The typical legislative intent is to avoid interference of one use interfering with the other. And I think it's been well established here that that legislative intent is met in that the sign will not interfere with the safe flow or operation of site circulation and the businesses that are there. D6, right? We've got D6 at the 60 feet. I think it's a good question. Why does it have to be so high? You have a building that's there. Again, we're looking to maintain that 9 feet of clearance over that building. Whenever we deal with height variance, we turn to a case known as the Grasso case, which really lays out the purposes of height control. Here, on the positive side, all of those use benefits that I cited above would carry forth, that the height is necessary to effectuate the use. The only case law that I think really helps in that regard was a cell tower case where height was needed, and the New Brunswick cellular case talked about height being necessary to effectuate the use. That was a totally different form of communication here, but again, this form of communication relies upon visibility, and that's why the applicant is looking to have the sign higher. Somebody asked if there's a taller building in the community. The answer is I don't know. The zone does say, if I'm reading it correctly, that you have this graduated scale of land masses, and I see 12 stories in the C2 zone. This is the zone we're in. So again, we can talk about what that intent is, but it's there. It's there in your zone. And so I do have to consider what is contemplated in the zone scheme as part of my planning analysis. That height also helps with proper clearance over vehicles, trucks, objects in the landscape, trees, power lines, and the like. So it just makes it easier to see and get the message out.
Sorry, I don't mean to interrupt you, but where does it say that we can have a 12-story building?
I think I said 4, I think I started 416-18.
There is a section that under certain conditions for specific uses, there's a graduated scale of what's permitted.
I
Do
thought I
you
would
meet
get
that
some.
criteria?
Want me to read it?
Do you meet that criteria?
Not on this lot, we don't.
Okay.
But the question, I'm
That's
just
my
trying,
question, thank you.
I'm just trying to answer the question about the height, that's all.
Something to look at for another.
So in terms of the negative criteria, purposes of height control on the Grasso case, the added height will not block scenic views. The added height will not create a population density that exceeds the carrying capacity of the land. The added height will not give this site an unfair advantage, height advantage, causing it to direct runoff onto adjacent lands. And in my view, the board can certainly give its own deference to this, but will not create an obtrusive, imposing structure in the context of the landscape. So that's certainly a subjective analysis there. But those are the purposes of Grasso. I think this can also justify the D6 height relief that the applicant is seeking. Lastly, Mr. Chairman, I'm looking at my time here. With respect to the C relief, I'll just bundle them up under the flexible C balancing test, where the benefits of the application as a whole would substantially outweigh the detriments. We've got a case there called the Pullen case, P-U-L-L-E-N. In terms of the positives, I'll just take all of those use positives, I'll carry them down. The setback relief, that uptick of impervious coverage is necessary to effectuate the benefits that I've given you. In terms of detriments, I believe setback and coverage relief can be granted without any substantially adverse impacts. The pole is relatively slender compared to a building. The sign panel is elevated, so light and air in terms of where we would normally experience it is not material impacted. And as I said, the setbacks do not interfere with site circulation or any safe lines of sight.
Now, have you had the opportunity to review the review correspondence provided by the board of experts?
Yes,
And do you agree with the zoning chart and proposed variance relief that they have also cited in their reports?
yes, I do.
And have you identified any comments from the board staff that could not be addressed by the applicant or prevent the application from meeting its burden of proof?
Not at this point. I think our witnesses before me have handled most of that.
Now, in your professional opinion, is the proposed use suitable for this location?
Yes,
In your professional opinion, has the applicant satisfied burden of proof of the variance relief being sought?
yes,
Do you have any opinion as to whether, if the application is granted, will it cause a substantial adverse impact upon the traffic operations of the existing roadway network?
again, relying upon expert, uncontroverted traffic testimony. I believe that this, application can be granted without any substantially adverse traffic effects.
And do you believe that it would have, that the application be granted without any substantial detriment to the public good or substantial impairment to the intent and purpose of the zone plan and zoning ordinance?
Yes, for all the reasons that I stated above.
Do you have anything else, or?
No, I think this is a good use of land. I think this is a good fit on this particular site. Land uses are balancing, and I think there are positives here. There's certainly considerations of potential negative impacts. We always look for absence of negative criteria. It doesn't have to be a complete zero. It just has to, can't be a substantially adverse impact. That's the key.
I know we've hit our stop time, and I think that.
You just got it in front of the wire, well, right at the wire.
Can I just ask for a clarification real quick? Just going back to that ordinance that you cited for the 12-story proposition here in town. Just for the board's edification, can you read the title of that ordinance?
Yeah, I have it here. Let me get to it. I have it. Okay, so this is, in Article 6, Supplemental Use Regulations, Section 416-18. Go too fast, just let me know. It says floor area ratios, FAR, and height limitations for office. How did that happen?
Yeah,
Somebody just pulled the plug on my internet.
And hotel buildings and the C2 commercial building district, can we agree on that?
Yeah,
All right,
And
this
then
is, this is not an office building or a hotel that we're talking about, right?
but the only reason I was bringing that up is somebody asked, what's the tallest building in?
Yeah, that was me, that was me.
And I'm just pointing out that you have a zoning board, because somebody else asked, what could go on this what could go? When you do a land use analysis, do you consider what could go on? I think one of the interested parties was asking.
But we're here to talk about your sign application, so we're not talking about hotels and office buildings, and certainly this doesn't even have the size requirements. And you brought it up, so I just want to kind of like take it out of the equation, because doesn't really apply to this particular application, correct?
I'm
This
not taking
ordinance?
it out of the equation. In my
So
plan.
you're saying this applies?
I give
That's
deference to
fine.
it. You can take it out if you want, I'm not.
Now, that he didn't testify that that ordinance applies to this.
I'm asking, that's my question to him, and he just said yes, or he
You-
just said he's not taking it out of the equation.
You have an allowance in your C2 zone district that allows for 12-story buildings. That's all I'm saying. It's a fact.
What's the lot size?
This is 18,000 square feet.
Okay, so for the hotel
35 feet.
ordinance, it's 60,000, right?
Yes.
Thank you.
Thank you, gentlemen.
Thank you.
Yeah, I think what we need to do now is pick another time. To check us. Who's controlling this now?
The next meeting is January 14th.
You guys do that. Which one?
Well, we could. You have the agenda?
There aren't any other applications pending at the moment. The one after, it's 2 weeks after that is the next meeting, January
Is there general availability for January 14th?
28th.
Work, yeah.
Applicants good, objective?
I'm checking. I think you need me here.
Well,
Yeah,
you're
yeah.
kind of central piece. Yeah, so. 14th, January 14th? Okay.
Our engineers, is not available, but
I believe.
Here's one other, pencil, is that?
You won't be there, somebody comes,
Yeah. You didn't make your partner come back with the 14th?
One of us will be able to handle it.
Very good. All right. Thank you everyone for your indulgence this evening. Hold on. Yeah.
One, just, I mean, I think the public, this meeting is gonna be adjourned to January 14th, 7:30 P.M. There'll be no further notice, nothing in the newspaper, you can mail, this is your notice, we think. Next thing is the applicant consent to any time between now and that date.
Yes.
Applicant,
Thanks, Major.
happy holidays.
We got a motion and a second. There is a motion from Mr. Caslin and a second from Mr. Cray to adjourn, and everyone agreed.
Okay.
Just that. 5 minutes.
Having fun, yeah, it's the big.